Good morning, everybody. Welcome to day 12 of the Grace Schara wrongful death jury trial. Today we're going to be closing arguments. There may be additional jury instructions, jury forms, verdict forms that are going to be worked on today. So far, the stream from Children's Health Defense hasn't been set up yet. Looks like they might just start this at the very last second. Hopefully they get started on time here. I will continue to make sure that we got this going. So my take so far and everything is pretty much the same as the first week, where the hospital is negligent in many regards. They over-sedated, overdosed, whichever terminology you'd like to use, Grace multiple times. She died within an hour and a half of being given morphine, while also on multiple other central nervous system depressants that looks like she simply succumbed to not being able to breathe by the fact that she was giving all of these um, breathing or respiratory system depressants. They tried to slow her breathing down to allow her to get more oxygen in when she was breathing, and I believe it had likely the opposite effect. Yesterday, when Dr. Shokar came back to the stand and the plaintiffs were asking him basically who did what, who made the choices, he did a lot of finger pointing at the nurses. Uh, because the hospital is a named defendant and Dr. Shokar himself is a separate named defendant and not a direct employee of the hospital, it is in his benefit to blame the nurses if he thought the case was going against him. It's probably what his lawyer told him to do, meaning that they think that they're on the losing end, which is a good sign and a good place to be. The finger pointing is just helpful in this particular case. Hopefully, we'll get started here in a few more minutes. I'm excited to see what the Werner Mendenhall's closing argument is going to be. He had such an amazing opening statement. Also, to know, I also know that the opening statement is not on my channel. I didn't actually start streaming until day 2. Once this trial has wrapped up, I will be streaming the day 1 just so I can have that opening statement on the channel so you guys could review that. We're still technically a couple minutes from go time. I decided to start the stream a few minutes early today because the court started the stream a few minutes early just about every day so far. So looks like I may have jumped the gun by a few minutes. Should be going in just a schedule for this week looks like it'll be a day and a half of closing arguments from each team and then jury deliberations. Um, it is entirely possible that the jury may go to deliberate before that, but based on the back and forth between the lawyers yesterday, my thought is that the closing arguments are going to be longer than expected than the day and a half they've allotted. So we shall see what timing looks like. The judge originally thought that we would be wrapped up with verdict by Friday. I'm not quite sure that'll happen, but I guess we'll find out. Something to consider about our delay this morning is there might be um, motions or hearings that are happening doesn't want televised yet. So I appreciate everybody's patience. We should be getting started shortly. I did just check the court website. It does look like it is officially scheduled for 8:15 in the morning, so we do have another 10 minutes or so. Uh, Also to note, every single day it's been noted for 8:15 in the morning, but we've started about 5 minutes to 8. So again, I appreciate everybody's patience. Should get going in just another minute or so. For those of you just joining us, we're just getting uh, ready to start the day. It looks like they're starting the stream just a little bit later than they have far in the trial. Today will be closing arguments, and I'm sure more arguments over jury instructions and jury forms. Still started. The court official start time is 8:15, so we officially have about 5 minutes. Appreciate everybody's patience. So, a comment on my audio. My audio is terrible. I am in a concrete and brick room. I live in Greece at the moment and don't have any wall treatments. My new office is currently under construction. A few more days, and I will be moving into that, and the audio will definitely get better for future streams. So it looks like the stream is officially late starting. There is no other source. I've checked every other possible location for another source. They just haven't turned the cameras on in the courtroom yet. My guess is that they are doing some hearing with the lawyers prior to starting that they didn't want to have on camera. They did shut the cameras off a few times during the lawyer conferences yesterday afternoon. So I'm assuming that they're starting the day in a similar manner, where they didn't want the public to watch whatever they're talking about at the moment. Let's be patient for a little while, and hopefully we'll get this going soon. All right, they just put the stream up. It does say a timer of 45 minutes start time. I do not know if that is going to be accurate. It seems that I think that they start with that timer every day, and it never runs out before they actually start the stream. So uh, we'll just be patient, and hopefully it'll get started sooner rather than later. I appreciate you guys sticking around and literally watching and listening to not much other than me rambling on. We'll get started shortly. Thanks, guys. So the timer stopped counting down. I'm hoping we're going to start any second now. I appreciate everybody being patient for our late start today. Uh, the only thing I can think of that they were doing prior to the normal start being public could possibly be settlement conferences, because those are definitely private. While they've shown every other type of conference and hearing, um, they didn't show whatever was going on this morning. So I guess we'll find out shortly what's going on.
From what the court reporter told me this morning is that the juror walked over to her table, the court reporter's table. They made eye contact, and the court reporter said to that juror, "We're not talking about it." And that juror said yes. And so that was the extent of the conversation. I would expect that that juror will probably report it tomorrow morning. And I don't know if anybody's worried about it or wants me to take it further, but I'd like to be focused tomorrow on and try to avoid the non-issues. So I thought I'd bring it up today, ask for comment, input. Start with you, Attorney Boylan.
I think we would wait to see whether the juror 630 notifies the court of this matter. Similarly, when we were at church on that Sunday morning, we saw the juror there. Nothing happened, but we wanted to notify you that we saw them, and I would like to see if the same.
Have we ever identified which juror by number that was?
Oh, I don't know the juror numbers.
Okay. Anything on the issue, Attorney Frankowiak?
Your Honor.
And Attorney Guzine? Okay. So I want to start this morning in hopes that we finalize the verdict discussion before the first break. And maybe we can do it a lot sooner than that, and then we'll just get into the instructions. But I tried to communicate with my emails with all of you. And I will try to make a record of those emails. But since we finished yesterday, everyone have received what I've called draft number 5, draft number 6, draft number 7, then a revised draft number 7, and then draft number 8. Draft number 5, I believe, is consistent with our discussions through the end of the court hearing yesterday. Represented where the court was at that time, and everybody had made certain objections, their dissatisfaction with it. Draft number 6, as I explained, I believe in my emails to everyone, simply kept the content of draft number 5, but it separated Dr. Shokar into 2 different questions. Questions 1 and 2 became the negligence question, or questions without the informed consent. Questions 3 and 4 were created, and they involved Dr. Shokar with the informed consent. And then the rest of it just kind of followed suit with the same as copy number 5. I believe that all happened last night, late. Draft number 7, I believe, was draft number 6, but it removed Mr. Schara from the verdict form. I wanted us to, consider that discussion because I said in my email last night I still wasn't fully comfortable with him being on the verdict form. So my thought was when we'd start today, we'd have what we finished with yesterday. We'd then have this draft number 6, which separated the informed consent from the negligence, which I think is what you were pushing for. And then draft number 7 would be that updated number 6. And in the event that we didn't include Mr. Schara, it would kind of be what that looked like. Draft number 8 of the verdict form, which is the one that was photocopied and handed to each of you by staff just a few minutes ago. And I think the most recent version of that was sent to you at approximately 8:30 this morning. And that I'm probably most comfortable with right now. So I'd like to just kind of start. And if you like number 5 or 6, then talk about it when you have your position. But I'm going to walk through my thoughts on it and explain the reason that it's drafted the way that it was. I agree with Attorney Guzzi that with respect to Dr. Shokar, there should be an ultimate fact question for both the negligence involved in treatment and an ultimate fact question involving informed consent. Draft number 8 has those questions as number 1 and number 3. I think it's best, it's cleaner, and it's probably more in line with what the jury instructions suggest or encourage us to use. When I made that distinction or separated those out, you probably noticed that the 3 negligence questions as relates to care and treatment are now listed as 1A, 1B, and 1C. And the 3 sub-questions that involve informed consent are now listed as 3A, 3B, and 3C. You will notice in the draft instructions that I sent to you that the opening paragraph talks about 8 questions. And then there are different categories of additional questions. And we can get into that later, but I tried to distinguish between, the questions that we need them to answer and then the additional questions. I'm looking at, I just noticed for the first time, so the draft number 8 that you all have, are your questions 9 and 10 misnumbered? They should be 7 and 8 on page 8.
Yes, Judge. And when I submit my proposed verdicts, I always leave the numbers out because they always change.
Okay. So I changed that. So I must have, when we had this photocopied, and I just want to make sure that my most recent to you is consistent with what the copy was that was made. Yes, so it was. So I broke out those questions, and I have the care and treatment questions under number 1 as 1A through 1C. The informed consent questions with question number 3 as 3A through 3C. And then as it relates to your clients or your client, Attorney Frankoliak, number 5 and 6 really did not change much in terms of overall structure of it. I made a note, and I'm hoping each of you had a chance to read it, but at 8:47, I sent you that verdict form again, and I removed effective communication. And that's going to, I'm going to get in line, and I'll just read to you the email in case you haven't reviewed it, but it says attached is special verdict form number 8. I removed the word effective from any references to effective communication in questions 5A through 5G. By removing the requirement that the communications be effective and requiring communication, I am more comfortable that there is no justification that Mr. Schara be included on the verdict. Arguably, Mr. Schara contributed to the communication or miscommunication issues with the nurses at St. Elizabeth Hospital, so I do not think it's necessary that the nurses communicated effectively. There was no evidence that there were any communication issues between and Mr. Schara. Thank you. And that was the end of the document. In not including Mr. Schara on the verdict form, I've contemplated that, expressed a couple weeks ago some questions or concerns about it. But I want to just start by my analysis, Mr. Guzzi, with what you identified as like ordinary cares, what you told me. So I started my analysis with jury instruction 1005, which I believe is the one that you were referencing. And that instruction would require that a person is negligent when he fails to exercise ordinary care. Ordinary care is a care which a reasonable person would use in similar circumstances. A person is not using ordinary care and is negligent if the person, without intending to do harm, does something or fails to do something that a reasonable person would recognize a reasonable risk of injury or damage to a person or property. 107, jury instruction, which is the contributory negligence. I'm not going to read that whole one. That whole instruction is a lot longer. But it indicates that every person in all situations has a duty to exercise ordinary care for his or her own safety. This does not mean that a person is required at all hazards to avoid injury. A person must, however, exercise ordinary care to take precautions to avoid injury to himself or herself. I was for the last 24 hours with Dr. Shokar's testimony yesterday, when he testified, like there's something to the effect of like, when you have these informed consent conversations, there's no wrong answer. That these are tough, these are emotional, we give the information and there's not a right or wrong. Just that Mr. Schara was negligent because he made a decision to do not intubate or to not ventilate. Seems entirely inconsistent with even what Dr. Shokar testified to. And then I got your letter this morning, Attorney Boylan, and I reviewed the Supreme Court case that you referenced, and that was Supreme Court, right?
Yes, sir, Justice Abrahamson.
Okay, and you go, okay, well, that's kind of what I'm doing. Now,
I did.
is on that string, and make a copy of it for you so you have it.
I don't need a copy.
Okay, and so, I'm not entirely persuaded by that case, but it talks about contributory negligence, which is why I added in the 1007 that we just talked about, as opposed to what you identified, Attorney Guzzi, as 1005. And then I thought to myself, and this is the scenario that I have been using since yesterday when Dr. Shokar was testifying it in my mind. If Dr. Shokar would have ordered A through F, and a patient doesn't comply with that order, like take these medications or go home and do rehab or whatever, and you don't do what was ordered, then I believe you may be contributory negligent. Here, when Dr. Shokar was having this conversation, he's not ordering anything. He's not telling them what to do, and they're disregarding it. He's giving them the options, and then they're making a choice. If that choice caused the death, as I said before, I think it then is not malpractice or not violating the informed consent. And that's different than, that situation where you're disregarding or order from a medical person. I think when I read your case, Attorney Boylan, the one that you cited this morning, I picked it off my shelf and I started reading it, and then it reminded me that you go, well, you can be negligent, if you're interfering with the care, the treatment potentially, or doing things that are contrary to what the doctors or the staff want. I don't think that applies at all with Dr. Shokar. So if you look at number 1A through 1C, you go, well, that's not to do with Mr. Schara. However, I think it might with the nurses. So, if he was a jerk to the nurses, or he was abusing them, or making things false, turning off alarms, whatever it is that they're suggesting, then he may be, responsible to some degree for that. However, how do we break that out on a verdict form? I think we'd have a whole bunch of different comparative questions. So the more appropriate method, I thought, with the evidence that came in is, I think nurses have an obligation to communicate with patients and their power of attorneys, regardless of the difficulty or challenges that that patient or the power of attorney create. And so if you take off effective and you say, well, all they had to do was communicate, and if it wasn't effective because Mr. Schara wasn't listening, if it wasn't effective because Mr. Schara was a jerk, then that's on Mr. Schara. And instead of being negligent, nurses did what they could do. They tried to communicate, they tried to educate, they tried to go back and talk with him, and which is what you're going to argue, Mr. Frankowiak, and that's all in those exhibits with the medical records. Then they just find that they communicated to the degree that they needed to. So that was kind of a summary of everything I thought through and tried to work through in removing Mr. Schara from the verdict form, which then impacts that comparative negligence question. And I think that's probably a summary of where that draft is at. So what I'd like to do is, if we're working with draft 8 with the explanation that I just provided, start with you, Attorney Boylan. Any objections, concerns, issues with drafted? And then I'm going to go to you, Mr. Frankowiak, and then Attorney Guzzi. I should go to you, Attorney Guzzi, first, because I see you shaking your head in agreement with most of the things I was just saying, and Mr. Frankowiak is staring at me with like disdain. So, and he can't see you shaking your head in agreement. Attorney, and none of you are waiving any of the arguments that you made. I don't think you have to rehash them or restate them.
I appreciate that, Judge, so much.
So we'll go to you, Mr. Boylan.
Judge, I don't have any to this draft number 8 from 8/22 this morning. I have one request for an addition, and that will be all that I ask you. And I think that after draft 8, it's time to move on, and the arguments have been made, the legal arguments have been made. What I think factually is missing from question 1, I do think there should be a 1D, or that either 1A, B, or C should include. Dr. Burdine testified that it was a breach of the standard of care, and it's in Dr. Burdine's report about the synergistic effects of Precedex, lorazepam, and morphine. And nowhere in 1A, B, or C is lorazepam mentioned. So while lorazepam may not be mentioned I suggest that it would be appropriate to include a question, either 1D or added to 1A, B, or C, that it was that Dr. Shokar violated the standard of care allowing the combination of the Precedex, lorazepam, and morphine at the dosages they were given their synergistic effect. And I just based that on Dr. Burdine's testimony. And that is my only request regarding the entire verdict. And with that, I'll have nothing more to say unless the court has questions for me.
I mean, the question that I would have, as I often have with each of you, is so I want you to tell me how you think it'd be worded.
It could be under question 1A regarding he was negligent by ordering morphine on that date and time to Grace in combination with the ongoing administration of Precedex and lorazepam. Question 1A. Or there could be so I'll stop there. Could be added to question 1A in that way. Or there could be a question 1D that says, we find that Dr. Gavin Shokar violated the standard of care by ordering lorazepam in combination with the ongoing administration of Precedex. Actually, Judge, I think it's most appropriate in 1A. Because if we put it in if we make a 1D, there's no reference to the morphine. So as a 1D, let me start again. I'm sorry to the court reporter. I'm so sorry. 1D would be.
I thought you said just add it to 1A. Or now you're saying 1D.
I think that the morphine itself was a separate breach. So I think there should be a 1D, but I do think that the court could decide either of these, but I do think there should be a 1D most appropriately based on Dr. Burdine's testimony that the combined synergistic effect of these was also wrong in addition just to ordering the morphine, because the morphine was to slow the breathing. And yesterday I'm remembering that we took the morphine to slow the breathing out. So I think the morphine needs to stand on its own. So I stand corrected. I don't think it is most appropriate as added to 1A. Because took out to slow the breathing part of that question. So I think there should be a 1D that says the following. We find that Dr. Gavin Shokar violated the standard of care by ordering the lorazepam and the morphine in combination with the ongoing administration of Precedex to Grace Schara on 2021. Otherwise, the lorazepam is nowhere in section 1.
Just give me a.
Thank you, Judge.
I'm going to Dr. Burdine's testimony. And I knew that would happen today because I left a bunch of stuff back in my office that I didn't think I would need, including rough notes from his testimony. Just give me a second. He testified over the course of 2 days. During the first day, he provided testimony about synergy. He also discussed each of the 3 medications on October 13th. But view of the record, to the extent that I have it, didn't offer that specifically. So I'm going to look now at his testimony on day 5 of the trial on June 6th. And it seems like the bat, he gets into that testimony, that the administration of the Precedex, lorazepam, and morphine were used to overdose Grace with this synergy effect. He went through exhibits 25, 31, and 41, which were the 3 medication documents. However, when he offered opinions, my notes indicate that his testimony was that given the verbal order for lorazepam on October 13th was a violation of the standard of care, and that's part of number 3 now. So we have that in the informed consent. He testified, as I indicated, that given the Precedex was insane and a violation of the standard of care, which is why I have 1B and 1C. And he testified that given morphine for breathing violated the standard of care, which is 1A. As I said yesterday, he testified that given morphine to an unconscious patient was the worst clinical decision that he'd ever seen. I don't have it down that given the PAM in his testimony. Well, here's what I have in my notes. When the lorazepam was administered at 11:25 a.m., the respiratory status deteriorated. The best decision, in Dr. Burdine's opinion, would have been to put the feeding tube on hold, so the lorazepam was not to be given at that time. At 5:46, when the second administration of lorazepam was given to Grace on October 13th, his opinion was it was not beneficial. It suppressed respiration at a time that didn't make sense. In his opinion, there was no reason to give lorazepam because Grace was Solomon and was not agitating, or it had no agitation. And then at 5:49, he testified that the third dose of lorazepam, she was still somnolent. The record says that it was given for work of breathing. In his opinion, the work of breathing was the only thing keeping her alive. And then he gave his opinion, and I have a star next to it here, that, all of that, and he says that in his opinion, Dr. Shokar's verbal order for lorazepam was a violation of the standard of care. So he focused on the verbal order being a violation of the standard of care, and your result of that.
He's going beyond just an informed consent. He's saying that actually administering it, whether it was verbal or written, was a violation of the standard of care because it interfered with her work of breathing. And I think the jury, I think that's a jury question. There's sufficient evidence from Dr. Burdine's testimony to make the lorazepam itself a question that the jury can answer about whether it was Dr. Shokar to order it apart from or in addition to the informed consent issue. And that's my position, Judge, and I'll stand on that, and Your Honor can make his decision after hearing from the other side. But even anything the other side, the defendants can say, it makes it a dispute of fact, and the jury, I think, should decide it. That's all I have on the verdict, Judge.
Okay, so let's stay focused on that issue only. I tend to agree with what was just argued, and maybe I stand corrected, and I'm not too proud to say that. So,
I don't think. I think to accommodate Attorney Boylan's concerns here, I think you just change question A to an and/or question. You find that Dr. Gavin Shokar was negligent by ordering the use of morphine and/or lorazepam. I don't think we have to get into complicated questions about synergy or anything like that, because that's, if they want to make the argument in their closing that all three of these in combination, I mean, that's the synergy. And as far as his testimony, I don't know that there was any actual evidence that there was a synergistic effect in this case. I think it was more in the context of there could be a synergistic effect. So I think
I'm not going to include synergy in it.
Okay, I think the simple fix. I mean, I can't sit here and argue and say that lorazepam shouldn't be included in these breakout questions, since this is the route we're going. So I think it can be handled with an and/or in the first question.
Okay, and in light of our whole thing, I'm changing 1A to 1C, just so that the time works. We're going to start on October 12th, and so the prosthetics is becoming 1A. October 13th, prosthetics is becoming 1B, and now we get down to the 13th after prosthetics is administered. If you follow your line of thinking, Attorney Boylan, there's prosthetics on the 12th, and that's a violation for whatever reason. Then all of a sudden there's the administration of the lorazepam and the morphine.
Lorazepam came next, and then the morphine. Yes, Judge.
So what's the harm if we were to say we find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam and/or morphine on October 13th, 2021 to Grace Schara? And you can argue the fact that prosthetics was being administered and he orders these two, and the combination of it was the problem.
The harm, Judge, just generally, I am personally confused by and/or. In your hands.
Right. Attorney Frankowiak, any thoughts on that?
Relative to that particular change or the entirety of it?
That only.
Looks like that one would only pertain to Dr. Shokar's question, so I don't think I really have any issues.
Okay, so for right now, what I've done, is I've added on a 1C, which reads, we find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam on October 13th, 2021 to Grace Schara. And then 1D is what was 1A. Our effort is to figure out that it makes sense. I think doing it and/or makes sense too. And they're only going to answer it if they find there's some issue with the care and treatment. Okay. Anything else from plaintiff then, Attorney Boylan?
That's all, Judge.
Just give me 1 second. I want to just get the verdict form back to current. I'm going to start with you, Attorney Guzzi, on questions, concerns, issues with the verdict form as drafted. Do you want me to print off what has been updated so everybody has that in front of them, prepared to go?
I think I'm satisfied at this point with my overall satisfied with how this section is worded. The separate cause question. Nothing else makes questions easier. Consistent. The only other comment that I have on the comment I raised in my email last night about separate itemized damage. Don't think that's appropriate. I think we've got 8 things in 365. Talks about total non-economic damage recoverable at the bottom of the tree. Any action or proceeding based on contribution that demonstrates that any action or claim by a person other than individual or non-economic recoverable at the bottom of the tree may not be all healthcare providers, all healthcare providers acting healthcare services are found. I think that section contemplates a singular category of damages based on all of, I guess, where we probably have an argument is, are there separate occurrences? Or is the hospitalization one singular occurrence? And I think that's the more reasonable view. So, and I look to see if if there was anything that would shed more light on the phrase or the use of the term occurrence, and I didn't find anything. I admit I didn't do a deep dive search. If you read that statute in context, I think it is referring in this case to the overall hospitalization. So whether beyond that, there is no instruction that identifies what type of you would recover for a breach of informed consent. It just merely says you're entitled to damages. So I think that's a category of damage that doesn't exist. And it's rolled up into the overall non-economic damages available to a patient or an injured patient in the context of a medical malpractice lawsuit.
I'm reading the right document. So you said you sent something last night.
An email when I sent the instructions, I just made the one note that I had concerns about email at the time.
I have it in front of me. So what you were just reading is that instruction 1741?
It's not an instruction, it's the statutory provision of WSStat 893.55 4B.
893.
0.55 sub 4 sub B.
Okay. So the impact on our verdict form is, you're saying that section B should be eliminated?
Yes. And I think that would also reduce a number of the jury instructions that are proposed in terms of concurrent, non-concurrent courts. I don't think those apply in this type of case. I think the jury considers all of the alleged malpractice as a whole.
We'd agree to remove those instructions on the concurrent and non-concurrent.
Say that again?
With Mr. Guzzi, that we could remove the instructions on concurrent and non-concurrent torts. We'd also agree with Mr. Guzzi that under 893.55 4B, there is a total cap that can be recovered under the laws that exist now. On appeal, challenge the constitutionality of that. But there is that total cap. We agree with him there. But there's separate jury instructions on personal injuries for informing the patient, which is question number 3 to Dr. Shokar, and another different jury instruction for personal injuries for pain, suffering, and disfigurement and death, for 1. But we agree with Mr. Guzzi on most of what he just proposed. We think both those jury instructions should be given and both the lines should be on the verdict.
You're referring to 1741?
1741 would go to question number 3, yes, and 1766 would go to 1.
I don't agree that 1741 says that you are able to recover damages. You're able to recover damages if there is a violation of informed consent, if there's negligence. The problem is, unlike pain and suffering, which has a jury instruction that defines what the jury in making a determination to award pain and suffering damages, there is no instruction at all that defines a separate category of damages and what a jury should consider in a negligence or failure to or negligent informed consent way.
It's the general instruction, which is in the court's instructions on.
Can we just stick with the verdict form?
Right.
So I want to stay focused, and we're going to get to the instructions. There's just one thing I need to just make sure of.
And Judge, I'm only referring to the jury instructions in the context of why I think that category of damages doesn't exist.
Okay, so I think your last issue that you said, that you have a concern with the way that the question number 8 is worded, and your preference is that line B gets removed, so that all we have is item A, funeral and burial expenses, and item C, past pain and suffering?
Yeah.
Okay.
That's exactly what I think it should be based on 893.55.
One thing that I heard you say, I think, Attorney Boylan, is that you're in agreement to remove options for concurrent and non-concurrent that have been requested.
Yes, Judge.
Is there any objection to that from defense?
No, I think that's entirely reasonable and appropriate. Right.
So let me just change that in our jury instruction. So I'm removing 1722 and 1722A. Is that the agreement?
Yes. I think that would, I think 725 also falls in that category.
1725 also.
Okay, so I will remove those three by agreement.
Just while we're right there, 56 and 57 could also go.
Agree, Attorney Guzzi?
Yeah, yes, based on the verdict form and no claim for medical expenses, this can go.
Okay, and Attorney Frankowiak, you agree with those 5 being removed?
Yes, Your Honor.
See, Judge, the job's getting easier every minute here.
Looks like it. So I'm going to focus on the instructions since we just removed 5 of them by agreement. So when I get down to the damage is, and you do a little work on it because I'm still confused. I have 1700, that's still in there. 1757, I still. Is that needed?
Oh, that's one of the
You're in agreement, Attorney Boylan?
Yes, Judge.
Attorney Frankowiak?
Yeah, we're talking about 1757, which is the collateral source. Yeah, that would only apply if there's a claim for healthcare expenses, so. Yeah.
Get to damages, the revised instructions, just same page, we have 1700. We're gonna have to do some work on 1850, 1855.
Sorry, Judge, 1850 would also go because there's no claim for medical expenses.
No, funeral was in 1850.
Oh, I'm sorry, Joe, you're right.
It's okay, but it could just say recovery for funeral expenses.
1850. Is still in, so we just have 3, and we can circle back to that, or we can.
The only question I would have is that there's 2 instructions on pain and suffering. I don't know that both can be given. I think it's just the estate. Grace Schara herself is not a plaintiff. It's the estate of Grace Schara.
That would probably mean the removal of 1766.
Right.
1966 has been removed by agreement, right?
Judge, that's not one we touched, but I would agree to remove that so long as we can make clear in 1855 that Grace's injury includes death. We've had this conversation yet. We're not gonna list death on the verdict, but she died. And,
Listed on the verdict in the questions, but not in the one that you were talking about.
in the damage question, so again, it just has past pain and suffering, and then it would be disfigurement or death, and we took out disability. I just think that we're gonna include that or exclude 1766 on her, and only go with the 1855. I just think the 1855 could be modified to include death. She died. And that the verdict question number 8 now could say past pain, suffering, and death.
Agreement?
I don't, I think it's superfluous, and the measurement of past pain and suffering is from the time of the accident until death. Death in and of itself is not a damage. I mean, I think it's pretty obvious to a juror that we're here about a death. And again, in theory, they need to be instructed on what that damage, what to consider the context of death. There is no instruction on that. I think I believe that these jurors are pretty darn smart. I don't think they need to be told that they have to take into consideration, and if they get to the damage question, that they have to take into consideration the fact that she died. They know that.
Okay, let me just work with you, Mr. Boylan. I'm looking at 1855, which is the one you were focused on before with the word death, right?
I'm here, Judge. Yeah.
In that second paragraph, it's going to have to be touched up, but it says, sorrow the deceased consciously endured and suffered between the time of the accident, which will need to be changed, and death.
Yes, Judge.
You wanted me to change it to add death in somewhere else?
I apologize that we were moving around between the instructions and the verdict, and I just think that on line 8C of the verdict, it should also include the word death as it does in 1855.
Do you want another change to the verdict form?
Right.
I think is
Past pain.
Okay.
I think it should say death, consistent with the instruction.
All right, so I understand the plaintiff wants that issue. The Attorney Guzzi, your last issue is to remove B, and you'll get decisions from me on that, sometime before we finish today. I think that brings us up to you, Attorney Frankowiak. Concerns, issues, arguments with respect to the verdict form as drafted. You already have all your arguments from yesterday.
Sure.
Go ahead.
As I understand it, Your Honor, we've resolved the issue of the damage question, the personal injuries for lack of informed consent. That's no longer going to be an issue.
That's not resolved. That's the one that Attorney Guzzi has outstanding that I said I'm probably going to keep it in there for right now. Then we're going to do the instructions, and then we get done with the instructions, we'll kind of compare it back to the two. Same with Attorney Boylan's request to have death under 8C.
Okay, that would be one. Obviously, I would join in that one. That
Okay.
concern. In terms of the question of Mr. Schara on the verdict, I think just for the purpose of the record, I believe we made the request primarily because of the law, and specifically that would be the CONNAR, CONNAR case 68, Wisconsin 2nd 42. Just by my interpretation, I thought CONNAR 68, Wisconsin 2nd 42.
Okay.
And that's it's a Supreme Court case from 1975, and there's just a one statement in there that says the only one question must be affirmatively answered by the trial judge before submitting a negligence question to the jury. Is there evidence of conduct which, if believed by the jury, would constitute negligence on the part of the person or other legal entity inquired about? So I think it's not something even that necessarily needs to be. We wouldn't have to stand there and say he's negligent. I think that case, though, just stands for the proposition that, well, if there's evidence there, that individual should, even if they're not a party, or if they are a party, or if they're a plaintiff even.
What I want you to do, Attorney Frankowiak, is I'm just going to grab a pad of paper, and I want you to itemize one through whatever each item of evidence that you believe would support a claim of negligence against Scott Schara, even though there's never been any pleadings on that. So what came in at trial? Just start me with number one, without arguing. Just point me in the record where there's evidence of that.
Sure. I think one particular the start, I guess, was there was testimony that there was period of time, for example, from about the 28th of September, I think, until the 6th, for a period of 8 or 10 days or something, where Grace was symptomatic but being treated at home with things like ivermectin and things of that nature that were recommended by the FLCCC before any doctor was contacted. And then, of course, then the hospital eventually. There was some later testimony that,
if you don't mind, just what I want to do is just give me the number one period of time before the hospitalization.
Sure.
Number two.
Okay, that was the period of time before the hospitalization.
And so you want us to now talk to the jury about obligations, responsibilities, duties before ever showing up at St. Elizabeth?
No, I'm just saying that you asked me for evidence that was in the record that I think would potentially support that. So, I mean, that's just what I was identifying as something that might potentially support it.
Okay, and it would support negligence? And so I want to go back to the instruction that I read. A person is negligent when he fails to exercise ordinary care. So my understanding, Mr. Schara testified to, is that they went to a concert. At some point, she started showing like cold-like symptoms. They were monitoring it. I think they got on some medication. Then eventually they tested her because they were planning to go to a wedding. When they tested, she came positive. When she came back positive, they didn't go to the wedding. They stayed home and continued to treat it. They were monitoring her on the pulsometer, the level of oxygen. When that level of oxygen got down to a level of 88, they followed the directives that they were following, and they went to urgent care. Are you suggesting that is fails to exercise ordinary care from a parent or a guardian or a power of attorney person?
No, in fact, I'm not even saying I would necessarily argue it. The law says that this is a party that could or should be on the verdict.
Okay, so if you're not arguing it and that wouldn't suggest negligence, then what I want you to do, I'm just going to cross number one out and say, okay, it's not before a hospitalization. So what items of evidence would support negligence by Mr. Schara? Just give me a number one.
Okay, well, that was the number one because
but then you just told me that is number one all of that, and that supports the jury instruction that says a person is negligent when he fails to exercise ordinary care. You think that is a failure to exercise ordinary care?
Well, there was some later testimony that certain things like remdesivir and stuff may have been outside of the I guess window of opportunity, which would begin running at a certain time after symptoms first appear. So that comes into it as well. Like if certain things were or were not, potential availabilities.
But let me just if you don't mind, if he doesn't know about that at the time, like none of us did, so you're treating yourself at home, you're following protocols, and when things get to a level at 88, you go to the hospital. What I want you to do is, if you don't mind, because I don't want to spend all morning on this, I want you to articulate items of evidence, 1 through whatever number, that support a position that that item number is a failure to exercise ordinary care. Okay, because I think what Mr. Schara did is hopefully what every parent did. And I probably didn't do it with that much detail when my kid got COVID. I wasn't monitoring them by the hour, and I wasn't monitoring their eyes. I'd get home from work, I'd say, hey, how you feeling? Do you have your taste back yet? Are you smelling? You know, how do you feel? Did you get your homework done? That kind of stuff, which might be negligent according to you.
Well, understandable, and these certainly are all things that a jury would. These are all great arguments that a jury could certainly discount these things. Absolutely, I'm not saying that these are not absolute things that jury could consider.
Yeah, and I'm not asking for things that are discount or not count. What I'm saying is, let's just go to the law in the state of Wisconsin,
Sure.
And then tell me the items of evidence that would support that.
Okay. The only other things I would say, Your Honor, would be there was an issue of the tocilizumab, whether or not that was offered, but it was specifically denied. He certainly has explained why that was, and that's perfectly illegitimate. I think a jury can certainly say, you know what, he had every right to do that. Anyone would have done that. Absolutely. The last one I would say would be the issue of the ventilator once again. Again, no one has put that into an opinion that he was negligent for this reason. Of course, no one's going to argue that. It was, however, that there was testimony that it was offered. It was said this is going to be, her condition is concerning, and she can go at any time, and we have to know what you want us. And there's been testimony that even from his own experts, that ventilators were typically used even in their own hospital. Everybody used them. It was known they were effective, things of this nature. He has said that he did his own research and came to a different conclusion. Whether it's argued or not by any party at the jury, I think there's some evidence in the record that would suggest that maybe that was not a decision based upon his research that would have comported with the standard of care, ordinary care. So, I mean, that's it, really. I mean, those are the big things. They weren't specifically argued as a point by any expert, but they came out in the course of the testimony. And that's the only reason we suggested it, because I concede no expert has come out and said Mr. Schara was negligent. This is just stuff that came out in the course of the record. And for the purpose of the record, I just thought I needed to mention that the Conar case exists, and that was the justification we were using for asking or for at least proposing that this be there. Certainly, it's up to the court's discretion and whether this particular party goes on the record. But for the purpose of the record, I wanted to indicate that the Conar case was there, and that was the interpretation of that case that we used in order to suggest this in the first instance.
And all the Conar case stands for, I think, that a trial court judge should look at the only question for a trial court judge is if there's any amount of evidence that would support finding of negligence against the person, and if the answer is yes, then you would include that on the verdict. That's kind of what it said.
Yes. Is there evidence of conduct which, if believed by the jury, would constitute negligence on the part of the person or other legal entity inquired about? That's the basic proposition for which the case stands.
And that's what I'm doing right now with you. So, and there's 3 things that you've identified. The
right.
One, which is pre-hospitalization, I don't find that's any support for a finding of negligence. And I'm just following the instructions. So now we're down to the last 2, which is the medication that was denied, I believe, on October 6th or October 7th, early in the hospitalization that you mentioned. And
right.
then on October 13th, the decision to not be put on a ventilator or to not be intubated. I'll let you finish talking with co-counsel.
Mm-hmm.
Is there another one? Make the list. You were talking with co-counsel.
Yeah, he was just mentioning something. I'm
Is
sorry.
there a 4th one that you want to make before we?
No.
Okay.
Those were just the only things that.
And so my thought on that, and I said this yesterday, obviously not clear enough, or maybe with thoughtfulness that I should do, is when a person is in a hospital setting, or the patients in the hospital setting. And doctors consult with that patient or their power of attorney. And the patient or the power of attorney is informed, which is what your position is. And they make a decision based upon all of the information that the medical people provided them. If it turns out to not be a good decision, or something that hurts them, or harms them, I don't believe contributory negligence. I believe that would fall under, they didn't, the informed consent, that they were informed, they made a decision, and as a result, my client isn't responsible because it was a choice they made after we informed them about it. And that's where I struggle with, and I mentioned this earlier today, is I do believe that the contributory negligence of Mr. Schara may be an issue in the communication, relationship, contact, eviction type issues that existed within the hospital setting. But as it relates to informed decisions, and they make a decision, I don't find a basis to add on a contributory negligence for that. I think the second thing is I'm a little bit confused. I'm sure you guys are going to argue I'm not sure if it's the hospital's position that Grace was acting as her own person on October 6th. You know, the verbal consent given by Grace to go into the hospital, if they were counting on her as her own person, and when the transition went from her making her own decisions to Mr. Schara being, I've heard the terms spokesperson, major decision maker, power of attorneys, you know, when did that transition over? Was that prior to or after or around the time that this medication was denied? It seemed to me that made that decision, not Grace. And I'm not sure if it's the hospital's position that Grace was her own decision maker at certain times. You're shaking your head no, but then I'm not sure how she gets verbal consent to go in. You know, and I'm confused by all of that. But if he was the decision maker, then everything I just said rings true. And if he should have been informed and he made his decision, and your client's not responsible for that. So that decision regarding that medication back on October 7th isn't an issue anyway. Your clients aren't being asked to be a violation of care. The doctor is not being asked to violate a standard of care. There's nothing about informed consent on that issue. So I'm not sure it'd be contributory negligent. With respect to the ventilator, I've already given my thoughts on that. That if you believe Dr. Shokar, they had an intense, informed conversation, decision. Don't, you know, people make decisions both ways. It's just tough, and there's not a right or a wrong decision. That's the case. I don't know how we could find somebody contributory negligent for making a decision after being informed that you can't really make a right or wrong. And the issue that we're asking the jurors in part is, was that an informed conversation? Did it satisfy the informed consent? And if the answer is no, then I think that it was not informed consent. I think Mr. Guzzi's client, you know, going to be liable. If the answer is yes, then we're done with it. Then there's not going to be any liability by Dr. Shokar or your clients because they're not involved in informed consent on that issue. So I don't want to then merge a potential of a contributory negligence and an informed consent with the standard of care negligence, you know, if they find that. So for all of those reasons, your objection is noted, and I'm not going to include it. Anything else, Mr.
Yeah, I guess it goes against the sub questions, I guess, for 5A through D. I think there was some discussion yesterday. In fact, I thought we left it where we might be even adding cause. The question is, do we need to add cause questions for each of those subcategories? Know one way or another whether anyone who answers one of them are So we know we have the same people answering, cause for each of those. Otherwise, I'm not entirely sure what the effect of those is going to be. For instance, as we discussed yesterday, like if jurors 1 and 2 are dissent to the question 5 altogether, then we still have 10 that are okay with negligence. And those same 2 are going to have to dissent for question 6, so that we have a consistent verdict on negligence and cause. But if even a single juror then dissents on any of those subcategories, we do not have the 10 jurors we need for that particular element, because obviously the 1 dissenter plus the 2 dissenters for question 5 and 6 would eliminate having 10. We'd only have 9. So if there's, and I think we also might need to add then the cause. So I'm not sure exactly how that's going to work, because say 5A is answered yes, and then they check yes to 5A because they've already checked yes to 5. But there's 1 dissenter for 5A. Well, that's not going to be a finding.
1 dissenter or 3?
Well, we know that jurors 1 and 2 are automatic dissenters because they dissented to 5. So if any single juror of those remaining 10 on any of the subcategories dissents to any of the subcategories, that's not a finding that meets the 10 juror, the 5/6 verdict. So
right, so their answer would be no to 5A because they only have 9 of them.
Right, if they dissent, if there's any dissenters to that question, then that's not a finding, any, I guess, validity. And I'm not sure what.
Well, you don't, because I think you've hit something. I thought we answered this yesterday. So let's just deal with your hypothetical until we're satisfied.
Okay.
The answer question 5, yes.
Yes, 10 out of 12.
And 2 of the jurors answer no. So they move to 5A, and the instructions say on 5A, if you voted no on number 5, you must vote no on 5A. So those no's are going to stay and will be reflected on their dissents. But all of a sudden they get there and a third juror says, I don't think 5A is satisfied.
Right.
And they're going to say, well, geez, it's 9-3. I'm going to check the box, no. And then 9 people should list their name or their number that they dissented with that no answer. And so we're going to be told, hey, not only did the 2 that answer no to 5 answer no to 5A, but we actually have a third one. And we'll be able to see that. And then we're going to see the 9 people or the 6 people that would have answered it yes.
Okay.
So when we get the verdict back and we all meet first before we bring the jurors back, right? Because we're going to look at it, make sure it's consistent. We're going to be able to look at that. But assume that your scenario is built out and they have 3 names, or they vote no, and then they have 9 names listed as dissenters. We're going to say, well, that's not an inconsistent verdict. They followed the rules, they answered it no, and now they moved on to 5B. And maybe 5B, they have 4 people saying no. So they're still going to answer no, and now we're only getting names listed.
Okay. So each of those subcategory findings are not going to have any, I guess, what's the legal effect, because you won't have 10 people agreeing to that finding. I'm confused about what the legal effect of those subcategories will be. Like,
I think the legal, it depends on what the answers are, but in part, I think the big one here is it would provide some basis for a declaratory judgment ruling.
Okay.
I don't know if you've noticed that, but in each of the areas where the plaintiffs have asked for declaratory judgment from me, those questions are worked into those subcategories. And so I'm going to be given direction from not only on whether there was a breach in the standard of care or a breach in the informed consent, but they're going to be able to answer to me specifically, if the answer was yes, where that was. And that will provide me guidance, direction, and what they found based on the evidence when the plaintiffs come back after verdict and say, now we want a declaratory judgment. And it will avoid me speculating, guessing what their answer to 1, 3, or 5 was yes for. I'm going to be told about it. Not that I have to enter judgment, because I think I'll have discretion, but I'll be able to assess what they found as I'm exercising my discretion, since they're the fact finders. But that's the real legal basis that none of us have talked about out loud, right, in the last couple of days. But that's still the motion that you have for directed verdict for declaratory judgment. Mr. Frankowiak, that's the one you have remaining that we haven't decided, but that's denied. And then if you look at it creatively, those subcategories are going to frame those issues for us.
Okay.
Don't find negligence on 1, 3, or 5 makes my job easier on the declaratory judgment. There's no basis for declaratory judgment. If they find yes to 1, 3, and 5, but they then answer those subcategories a different way, I think it provides a basis for you to argue no declaratory.
Okay, so the declaratory judgment is still on the table, and that's to be decided at some point after the verdict.
Yeah, don't you think it's appropriate for me to wait till after the verdict to make those decisions?
Yeah, I guess I wasn't sure. As you said, we left it open, so I didn't know if we were going to decide that now or what the final version of that was going to be.
No, I think we've had a jury trial. I think my role was to say, well, I want to know what the jury thinks about this. I don't know what they think, but what I think and what they find will probably have a basis in what I do.
Mm-hmm.
I don't know if I can substitute my judgment for them, unless I really think it's some abuse or misuse. I do think there's a possibility that they find, for example, the DNR order was not informed consent, but I think I have discretion to not enter declaratory judgment. So all it does, you ask what substantively does it do for us?
Right.
It does a lot. It answers the specific issues in this case that have been pled. It answers those issues with specificity that will be beneficial to us in addressing issues after the jury doesn't know about, they don't have to worry about. And it will provide guidance, I think, in what they found specifically with this 7-day hospital stay.
Okay, and then in terms of, I guess, whether or not we need a separate cause of those, I'm not sure. Usually you need a cause question to determine if the same jurors dissent to the negligence and the cause. You want to make sure that's the case.
So you're talking questions 5 and 6?
Well, we know that we're going to need that. It's the same jurors are going to have to agree to those to have negligence and cause. Without the same 10 jurors agreeing on those two, we don't have a good verdict.
That's right.
But I'm wondering what we need to do about the subcategories. Like, does each category, say 5A, 5B, 5C, does that need a separate? Does each one of those also need a separate cause question?
I don't think so. And here's my rationale now that we discussed declaratory judgment. And I don't know if it applies to your clients, to be frank. The declaratory judgment has to apply to Dr. Shokar, right?
The actual pleading again.
Yeah. So let me just use Dr. Shokar, even though you asked the question, Mr. Frankowiak. And let's just do the one that has been most popular, talked about throughout the trial, the DNR order. So if are to answer 3C and they answer that yes, and let's just keep it simple, and they answer it unanimously yes. Follow me, Mr. Frankowiak?
Yes.
Okay, so I think for purposes of declaratory judgment, the answer to number 4 doesn't matter, because in order for declaratory, you don't need to cause damage. Make sense? So for example, if they answer 3C yes, and they answer 4 no, and so they never give a damage amount and they never do a damage calculation, I think we have our answer in terms of this verdict form, meaning there's going to be no monetary damages because it didn't cause death. But I think in that situation, the plaintiff could come in and say, well, 3C was answered yes, we want a declaratory judgment that the DNR order was entered without informed consent. And their relief is not monetary, their relief is the declaratory judgment. That's how I understand it. And if you, with that in mind, you look like you're maybe just hearing that for the first time, or you're squinting your eyes at me. So if you think through that and you go back to the questions and how they're worded, I didn't just, what you referred to yesterday, like pick things out of thin air. I tried to put thought into this so that 3 months or 6 months when we're sitting here figuring out what the jury needed or decided, we'll have some answers. So I'm not convinced we need a separate cause question, the way that it's drafted.
Okay. I guess my concern with the questions all along, I understand now the breakout questions are not intended, or they're intended to help answer a declaratory judgment. I guess
in part, I think there's other benefits to it, but yes.
I guess my concern with the breakout questions all along is that they're not material issues of ultimate facts, which I was concerned would violate 805. And I'm also concerned that they were they could be interpreted as unfairly prejudicial, and they set forth opinions, basically from plaintiffs' experts on the standard of care, which I'm concerned would invade the province of the jury. I mean, see where you're coming from, but
for ways to word it, let me know. But let's just take, for example, 5A. I don't know how that's worded to take the testimony of the defense expert or how it's unfairly prejudicial. Because we find that the standard of care required the nurses at St. Elizabeth Hospital. So they're going to have to find that there was that standard. That's something you guys can argue. Suggesting one way or the other. As a matter of fact, it's probably worded against the plaintiff because they have the burden of proof by framing it the way that they carry the burden because the answer needs to be yes, which I think is appropriate. And then it's just open for argument. But I didn't say, Nurse Eichinger said there's a standard of care, or Nurse Eichinger said this is the standard of care, and Nurse Eichinger said they violated it. I said we find, and not only do we have to find that, also find that they failed to satisfy it. Instructions as drafted.
No, I guess I maintain my objection stated yesterday as to the breakout questions under question 5, certainly for the reasons stated. But if the court is inclined to rule as it is, I anything further to mention at this time.
Okay. Yeah.
I may just with regard to the declaratory judgment, I am a little concerned about the lack of a specific cause question. Since I know we're looking ahead here in terms of how that declaratory judgment might go. If as the verdict stands the way it is, may answer. Please see. Yeah, that was what they answered question number 4. Now, would the declaratory judgment then indicate that there was a finding of negligence, but also a finding of fault?
I mean, you're asking me to commit to something, right? And I don't know the answer, to be honest. But if that's how they answer, number one, I'm not sure there's potentially a basis not to do a declaratory judgment. If I were to do a declaratory judgment, I think I would, if I found their verdicts made sense and were consistent, can't imagine that I would enter and say all it was is that they found that. But I think the fair thing to do would be to say what the jury found. They found a DNR order was entered without informed consent, and it didn't result in any injuries or didn't cause any injuries or death. If that's what in fact they found.
Yeah. No, I understand. As long as somehow,
Yeah, so I
a separate, not cause between the medication and the DNR, because I don't think the medication are subject to. I don't think that's important to control the declaratory judgment. The declaratory judgment is on the DNR, and I thought
both.
So
I think it depends on the jury's answer questions. I just think this is going beyond what we're here for. I understood Your Honor was going to take up the declaratory judgment issue. My position would be that should be tabled until the jury answers the verdict.
As far as I know, my most recent note from the plaintiffs, and I forget when this was, but my most recent note from them is they're asking for declaratory grounds for the improper administration of dangerous medicines that caused her death, and entering a DNR order without informed consent that caused her death. Yeah, I still think both are on the table.
Yeah, for that very reason, I don't know that we can have a verdict form that doesn't have them cause for those separate issues. Because if the court entertains the declaratory judgment act, they find yes on the medication, no on the DNR, no on cause. We don't know. I mean, you could extrapolate that they're only. I'm just sorry, just kind of thinking it through.
We do have separate cause questions for the medicine and the DNR. That's question 2 and question 4. And maybe a better word would be informed consent versus, medicines. So the application of the dangerous medicines are in what is now 1A, B, C, and D. The DNR is in 3C. The other informed consent with the medicines are 3A and B. The cause questions are different. They're number 2 and number 4. So I think the 2 issues we have left on the verdict form involve the damage questions. Defense wants B removed, and plaintiff wants C to include death. Other than that, I think we've had our discussion. So why don't we take a break? It's been an hour and a half. And when we come back, we're going to start with the instructions. I'm going to print off in the next couple minutes, and there'll be copies brought out to each of you. The most recent copy that I have that we'll be working from that include the changes that we just made when we removed a bunch of instructions.
I think you may have indicated that 1741 that we had agreed to remove, and I might have misheard that, but we that is at issue still, 1741 staying in the instructions.
Okay. I think I did say that, and I have a note here that you want 1741 in with number 3.
Yeah, so that's still in dispute. So the new copy, I just want to be sure, is still in the new copy, but subject to argument.
Okay, good. Okay, I know that's on my list of to-dos that added in. Okay, perfect.
I don't think there's anything terribly controversial there.
I'd say, why don't we wait and talk about it? Okay. All right, we're adjourned. If we say 10-2, 15 minutes. update of the verdict form. And in my email, I said 8B and 8C are left, so that's where we're at with that. Get you instructions, because when I went back to my computer, there were issues. But I think what I do in every case, and I know you have captain of the ship and all those things, but I just think the best process, everybody will get their say, is we just start at the top and we just kind of go through page one and we address it as we go. Just so everybody knows, so those numbers on the instructions, I usually keep the numbers and I cross out the word. Okay, so like, and I don't know if anybody has a problem with that, but where it says opening will be removed. And I keep it on there until I'm finalized. When I go, I'm good with this, and I take out the word. So you'll notice, like on 100, it isn't final in my mind, because first of all, we haven't talked about it, but the number of questions changed. So you see on the second line, when I was back in my office, I changed it to 13 instead of 12 other questions, because we added in 1D. So that's sort of the practice, but why don't we just start on page one, instruction 100, with the way that it's drafted. Does anybody have any problems or corrections, typos? Okay, and so I'll just keep going. So then we get to page 2, and it's instruction 103. I didn't know if this was necessary or needed, but it was required by one of you, and there were charts used. So my thought was just keep it in. And so if nobody has a problem with it, we'll keep that as drafted.
There were charts as opposed to chart or demonstratives. Could we address that at all? It says chart, a chart.
Charts if you want. I mean, every chart that we've used, whether it was Attorney Guzzi's charts or Attorney Frankowiak's charts or the ones that the plaintiffs put on the screen, we've marked as exhibits. So it's already been covered by the exhibits. But I thought I'll keep it in, because if a juror says, well, I saw that one chart and I'd like to see that again or something, I just want them to know that charts are things they can use.
Just the plural, that's all.
Okay. Any problem if I change it to charts?
No, Your Honor.
Okay. I've done that in the 3 locations where it's at. Then we go down to 110. That's a standard instruction. I didn't touch it. 115, again, standard instruction, and I didn't touch it. 120. Standard instruction, and I'm pretty sure I didn't touch it. And that takes us to page 3. There was stricken testimony, so I think that's appropriate. 145 deals with special verdict questions in a relationship. I don't know what you guys think about this, but I was thinking, and this is outside of the instructions, but tomorrow when we're instructing the jurors, I was thinking about providing each of them a verdict form. So when I'm reading it to them, they can follow. I've heard from various attorneys this is confusing. It might be trickery for them. So when we get to question, we say, look at question or whatever we do, they can look at question 3 and be reading it as I'm talking.
Judge, I myself am a visual learner, not auditory, so I do the same in practice. I think it's a good idea.
Attorney Guzzi?
I've never had that
Sure.
Would you?
I mean, my inclination would be, yeah, you're going to get a verdict form regardless. So.
Right.
Would you instruct before or after closing?
I instruct before.
Before closing.
Except for like that last paragraph. So I instruct, and then you guys, so they would have it when you're talking about it. So you can say, look at paragraph number 5, or if whatever you want to do, they'd have it in front of them.
be allowed to keep it during closings to reference it.
Again, we could have them turn it in, but to me, if you're making a closing argument, I think it'd be helpful to you if you're talking about number 4. And I don't know if, a lot of times attorneys throw it up on the screen or you put it up. They would also have it in front of them. So it's not something we want to hide from them. I don't think. I don't think anybody's harmed by them looking at it. The only thing is are they going to be distracted looking ahead? And I think I would just caution them when I'm telling them, like, listen, I'm going to give you the sheet of paper so when we're referring to it, you can see it with us. But I don't want you reading ahead until I'm instructing you, things like that.
Yeah, I guess that would be a concern if they're distracted by something that we give them and they're not listening to closings.
Right. But they'll already have a chance to go through that. So if they're not listening to me, but I'll be able to see it with them, and I'm doing that. And that used to be my practice, and I probably changed it. I don't know how many years ago, but just out of laziness more than anything else, that we have to make copies and get it to them and all those things. So I just haven't. But the jurors' feedback is they like it, they appreciate it. A lot of them are visual learners, so they can learn better when they're listening and seeing. And so I don't know if it'd be a distraction. So think on it. My plan will be to use it unless somebody brings it up ahead of time. Which kind of relates then to instruction 5. Any issues with that on page 3? Okay, and then 180 is the 5-6 verdict instruction. If you have any issues with the way that it's drafted, let me know. On the bottom of your page 3 is burden of proof. The ordinary. And then the top of 4 is burden of proof for compensatory damages. 215 is credibility of witnesses, weight of evidence. That takes us then onto page 5, or the bottom of page 5, and then at the top of page 6 is circumstantial evidence. 260 is on page 6, expert opinions. You can take a look. I don't know if there's a problem with the way that I use particular field or specialized knowledge. I was one side of me, sometimes I rattle off what their expertise is, but there are so many experts, radiologists, and so I thought the better approach would just call it expertise and specialized knowledge. 261 is the published treatises. That was requested by the defense only. It takes us on to page 7, expert opinion testimony with hypotheticals. Again, that was requested by defense only. Medical negligence 1023. So this is probably that first substantive one where we're going to have some discussion. So issues with respect to the way that was drafted.
Just give me one moment, Judge, please.
I can tell you, Judge, that I get to the second portion of this, if you have one at it.
The second portion of 1023.
Yeah, when we start the paragraph that says the evidence indicates self.
Okay. So
say the evidence indicates self-abuse. But when Dr. Shokar began providing care and treatment on October 12, 2021 at 6 a.m. That's accepted. I think the other language is more appropriate if someone.
So the evidence indicates without dispute that when Dr. Shokar, give me a second, and then I didn't like the way that this ended up being drafted anyway. I thought it was a little awkward. So what's after Dr. Shokar? How do you word it?
Dr. Shokar began providing care and treatment. To Grace Schara.
what I'm hoping we're gonna do, Mr. Boylan, is, just so something else, if we can get this done by like the noon hour, print them out, have you guys take an hour lunch, go through it all one final time and meet in the afternoon for any brief final comments.
I'm reading this part. I was just looking for those words without dispute.
At the top of page 9, the first sentence.
Yeah. See that, and then
So the way that it's worded, like what Attorney Guzzi said, the evidence indicates without dispute that when Dr. Shokar began providing care and treatment to Grace Schara on October 12, 2021 at 6 a.m. Okay, so that change is made. Any other comments?
yes, Judge. On the beginning of this instruction,
Okay.
it says in treating Grace Schara's condition. It would be appropriate simply to say in treating Grace Schara because she had multiple conditions and there's disputed evidence. There's disputed evidence on each side what all of those conditions were. So I don't want it to sound like that that it's conceded, that it's without dispute that he was only treating her COVID. Well, we would say, Dr. Burdine would say he was treating her body's reaction to an overdose. So it's not this study was treating her COVID. And I understand that Mr. Guzzi would say that, but certainly can't be put in terms of without dispute and beginning with treating her condition.
But it's in the context of treating her for COVID.
Well, he testified that she was past the respiratory distress phase of COVID, so there's disputed evidence on what he was treating her for. So I just think it should say, I submit it should say treating Grace Schara, not her condition.
In providing care in Grace Schara.
At the first line?
Yeah.
Yes. Different than that she had one condition.
That just in providing.
Well, and that would be consistent with the language that we use subsequently at the stage.
And then, Judge, back to this later part about the evidence indicates without dispute. The evidence, I think, the only part about without dispute is that when presented to the hospital, she tested positive with COVID. I just think it's not without dispute that she was still in this respiratory distress phase of COVID on October 12th, 2021 at 6 a.m. So I'm troubled by a statement being without dispute when this is going to be presented to the jury to determine.
Let me just understand. Are you saying that on October 12th at 6 o'clock a.m. she was no longer suffering from COVID-19?
I'm saying that's disputed. I think so. I think the jury can determine one way or the other. It's not without dispute. I mean, she had a positive COVID test. People can test positive for COVID or not. But Dr. Shokar testified that by the time he began treating her, she was beyond the respiratory distress phase of COVID. So he must have been treating her for something else as well. Dr. Fisk said he disagreed with that testimony, Dr. Shokar.
Response due to stress syndrome related to COVID-19.
And Dr. Burdine says the ARDS is caused by something else, not COVID-19.
Okay, so the sentence reads, the evidence indicates without dispute that when Dr. Shokar began providing care, I'm going to change Dr. Shokar started providing care and treatment to Grace Schara on October 12, 2021 at 6 o'clock a.m. She was inpatient in the intensive care unit at St. Elizabeth Hospital. That says a lot, right? So she was there because she was critical need.
I don't object to that statement.
This instruction is for the purposes of telling the jury that she has a health condition that they are not to consider in determining the negligence. So we have to specify the health condition.
Thought I did.
And I think, I mean, all due respect, Joe, that is a ridiculous statement to say that it wasn't COVID-19, that she tested positive, she went to the hospital.
It's not the only condition she was being treated for.
But those conditions, whether it's this alleged overdose, metabolic acidosis, it's all part of her admission.
According to Dr. Burdine, what she was being treated for was the fact that she had been overdosed on these 3 other drugs. It's not without dispute.
Argument in closing that in the context of her presenting at the hospital to be treated for COVID-19, something else developed. I mean, but it's not, this is an accurate statement, I think, of the record.
You just kind of interrupt so we're not arguing back and forth, but I think we all agree that when she went to the hospital, she was COVID-19. But we're talking about the time period on October 12th. So we're not talking about what she originally went there for, I don't think. We're talking about doctor treatment and care. So when he shows up, he's taking her in the condition that she was in.
And her diagnosis is COVID acute. If we really want to get technical, it's acute hypoxemia resulting respiratory failure due to COVID-19 or ARDS.
That's the cause of death, right?
That's the cause of death. That's the diagnosis.
And I'm not going to put that in.
There were Burdine disputes.
And so I'm comfortable with, and you guys can explain it how you want to the jury, but in terms of the instruction, I think what's important is she was on October 12th, 2021 at 6:00 a.m. She was inpatient in the intensive care unit at St. Elizabeth Hospital. That doesn't suggest one way or the other. And the is important is Dr. Shokar didn't put her in the hospital. He's not responsible for the condition that she was in on that stage, but his treatment, and that's the introductory sentence. The next sentence says, Grace Schara's physical condition at that time cannot be regarded by you in any way as having been caused or contributed to by any negligence on the part of Dr. That's exactly what I'm trying to say. And then this question asks you to determine whether the condition of Grace Schara's health, as it was when she placed herself under the doctor's care, has been aggravated or further impaired as a natural result of the negligence of Dr. Shokar's care and treatment. I think that
I think it's inconsistent with the rest of the instruction, because the rest of the instruction consistently refers to COVID-19.
The next paragraph, I think, is correctly stated that you will entirely exclude from your consideration all damages which resulted from the original COVID-19. The original, not at October 12th.
I understand, Attorney Guzzi, but let me ask something that's bothering me. We're not putting the damage instruction in there like it says, right? We're going to do that later.
I believe we still need to get to that, right?
Okay, so I'll keep it in bold. And so in that paragraph, you said inconsistent. I'm confused how that's inconsistent.
We're using COVID-19 throughout the entire instruction until we get to that paragraph. Then we're switching it up to say a condition that as of October 12th, 2021.
Yes, because
based on the premise that their expert says that her condition was something other than COVID-19. I don't think that's a fair I think to take that as the position and instruct the jury is I don't think is accurate. And I think it's, it's basically taking the plaintiff's evidence and disregarding what's in the medical records as to what at that time.
I'm confused. So when I drafted this, I tried to follow the medical records. So, and maybe I'm misunderstanding what this instruction is supposed to say. So if you start with the second paragraph, on page 9, it says she sustained injuries before the treatment by Dr. Shokar. I kept that bold, meaning the injuries might be COVID, the injuries might be the medical event on October 7th or October 8th. But what I tried to say is, whatever happened, the treatment by Dr. Shokar, you will entirely exclude from your consideration. Period. I don't think that's inconsistent or not accurate or different than what the medical records say, Mr. Buzzi, in that second paragraph.
Well, I mean, I'm not going to spend a lot of time arguing. I mean, that's the court's.
Well, I'm just trying to understand you. Like this, the second paragraph I thought would be defense oriented, meaning clearly says that whatever happened before Dr. Shokar got there should be entirely excluded, including the original. Notice I put original COVID-19 condition. Not disputed. I'm not mentioning those events on October 7th and 8th. I don't want to get into it, but I think anything prior to it. And then when we get to the morning of October 12th, if all I indicate is she was inpatient in the intensive detainees, you guys can argue whatever it is that the evidence you think shows her condition at that time. And whatever her condition is in that top paragraph on page 9, it can't be regarded by them in any way as having caused or contributed to the negligent Shokar.
Okay.
So I'll keep that in bold on 1023 and we'll circle back with the damage. But I think then that takes us to 1023.2, which is on the bottom of page 9. I think I didn't take yours word for word. So when 1020 was drafted, what I did was where it says question number 3 asks, that's off the verdict form. And then on the top of page 10, with a doctor, I just took what Attorney Guzzi submitted word for word and included the rest of that instruction as his document to me, all of us last night. Any issues with that?
The bullet point about information in cases, it is where the patient or the patient's power of attorney is incapable of consenting. Could it be where both the patient and the power of attorney are incapable of consenting?
No, this is the statutory language.
But this adds power of attorney rather than patient. That's where that was the change from the statutory language. For this pattern instruction, we're adding in power of attorney. I believe the court power of attorney.
Or did I add? Maybe I did.
So I'm just saying both rather than or. But Judge, this is not a big issue, and if you believe it should go, then it should go. Yes.
I think the or means whoever has the legal authority to make the decision is not available. And so if there's an issue on who had that legal authority, but I think and provides the same thing. We change it into and I don't think we change the intent. The intent is if the physician fails to perform this duty, inform, he is negligent in informing his patient. The physician's duty to inform does not require disclosure of information where that patient or the power of attorney is not available. or is not capable of consenting.
That's all I have on that one, Judge.
Attorney Guzzi or anybody else on 1023-2? Okay. Then when we get down to page 11, I think we're still in 1023-2 involving that do not resuscitate order. Do you want that in bold?
I think it would be, yes, I think it's separate instruction.
Okay. Okay, and maybe we can just give it another number.
Mhm.
Informed consent, do not resuscitate order, just so it's consistent.
I have to confess, being a visual person versus auditory, I'm not really understanding what you mean by in bold. I mean, I understand bold letters, but is that only for purposes of our discussion here or with the jury?
Yeah, so you notice how these have numbers and the title?
Yes.
So when I give to the jury the copy of the instruction, one that informed consent, do not resuscitate order doesn't have a number. So eventually I'm gonna delete the words that you're looking at, but I think we should put a number in there just so we recognize it's a separate instruction. They don't 123.5.
Sure.
We're not using that number, and it's right between the two that given. My thought we'd call it 1023.5.
And the in bold part is the number is gonna be in bold? That's
All of them are gonna be in bold.
Right.
So just be consistent with everything else.
There's nothing else to this in bold concept. I'm sorry, I'm missing it.
Okay. The only problem with that is, they're going to be looking at numbers and why is this one out of order? But we could call it.
I don't think I got
1023.25 because 2 is the one that deals with informed consent.
I guess it really doesn't make a difference.
Okay.
I've never attached numbers to the instruction, so I don't know what we prefer to work.
Do you have any issues, Attorney Boylan, with the instruction that Attorney did?
Let me get there, Jess, because I was looking at the 1023 numbers. This is on the informed consent, do not resuscitate order.
It's on page 11. Yes, and then it starts with a physician has a duty.
And there's another paragraph, you have her testimony. That's included as part of this 1023 point, whatever we're gonna call it. 25.
1023.3.
Yes, I agree.
Okay, so that's good. Then that takes us up to 1023. Any issues with that? Okay.
I do not.
That takes us then to 1023.7, which I think involves you, Mr. Francowiak.
Yeah, I would just mention, I guess, when this was initially proposed, I think both Nurse McGinnis and Nurse Barkholtz, I think were technically actual parties who were in the case. They've both since been dismissed. So I don't know that we necessarily need to identify them on the first line. It could just read, for example, at the time in question, the nurses working in the intensive care unit rather than singling them. since they're no longer parties, they kind of fall in the same category as all the other nurses.
Yeah, I don't disagree with you. And I updated it as recent as yesterday, and I kept them in even after the battery got dismissed. So it wasn't that, but it was. So it would read, at the time in question, the nurses working in the intensive care unit between October 6, 2021 and October 13, 2021 were registered nurses. And then the rest of it, I think that sounds good.
Right. I think that's fine.
Okay.
I don't have any other issues with this. There is a little optional thing at the bottom to insert appropriate burden of proof and insert appropriate cause. Will we be doing that, or are we just doing that separately?
And that's a good question. So let me ask you something. At the beginning of 1023.7, do we want to insert the question in the verdict form that we're talking about? You know, question number 5 asks, similar to what we did with, you know, instruction 1023.3. Probably makes sense to be consistent.
There and possibly also on the DNR order as well, the informed consent part.
Yeah. Okay, so give me a second to get those things done.
So would we be inserting that like question number 4, beginning of 0.7, like it does for 1 or 1023.2 and 1023.3,
Yes.
and then launch into the?
Yes. And again, everybody's going to get a hard copy of this and have a final kick at it just to make sure. But right now, at the beginning of 1023.7, I have question number 5 asked, and then I just cut and paste. Where one or more nurses at St. Elizabeth Hospital negligent with regard to the care and treatment provided to Grace Schara between October 1 and October 13, 2021. And then the next paragraph will be at the time in question, which is where you started with.
Then would there be a separate one for the cause question then too?
When let's kind of hold on that, because I think want to go back up to counsel what you said on the informed consent. Under 1023.2, I think you copy you have had question number 3 asked. Okay, so we have that in under the, you know, the new instruction, which we've called 1023.25, which is the DNR. I didn't want to call out question 3C. Again, my goal with 3A, or I'm sorry, with 3A, 3B, and 3C they're not the major questions. And so some level of different treatment, plus I don't see.
Fair enough, Judge. I thought Mr. Gussie had agreed, but if
I think
we
he did. Both of you agree, I will. I just want to make sure that I'm not given more emphasis on 3C than I am on 3A or 1A or anything else.
I don't think either would be wrong.
Attorney Guzzi, what's your preference? I'll do whatever you decide, since you know the impact would be on you. Under your DNR instruction that we're using, we're calling that 1023.25. Do you want the verdict at the first paragraph on that? And the question from the verdict that I'm referencing is question 3C. The rest of the instructions are not gonna be asking I'm not putting anything up there about 5F or 1B or 1D. So did you want to point out 3C?
I don't think so. Again,
That's what I've tried to do.
I'm not calling out the other subparts.
Okay. Now, Attorney Frankowiak, you asked a good question, and I think we need to talk about it. I understand the cause questions that are on the verdict form are really questions 2, 4, and 6, right? And
Yes.
so I'm okay with one cause instruction, 1500. That's on your page, and I probably have lost track of your pages, but I think it's on page 13 approximately, but mine are being adjusted as I'm adding up here. And we could say in answering question 4 and 6, you must decide. You want a separate one for each one, Attorney Guzzi?
1023 instructions I submitted don't have separate cause questions already. I think nurse has.
It does. I think the one that we submitted, I think on 1023.7 does have a cause question already embedded in it.
So there would be no need for 1500. 1500, if we submitted it, would have only been on the basis of therapy. I don't think it was necessary. And given what's involved in this case, we have to have a cause question related to
Okay.
And I just need to ask so I can get to the same page. Which is that, Randy?
I don't think it's in what you have.
Okay.
I don't, is it in the packet that I emailed you guys?
Yeah, at least mine, the 1023 and 1023.
Sent to everybody in the jury instructions this morning at 8 o'clock. It is? Okay, show us where, if you don't mind.
Yeah. Well, under 1023, I mean, we already talked about. And my page number is a little bit different because you're working off of your last revision here, thought. On the old version, this would have been the bottom of page 8. Starts the cause question, ask whether there was a causal connection.
And the first sentence of that is?
That's the first sentence. The question, the cause question.
You conclude from the evidence that the death of Grace Schara was caused jointly.
No.
Now the cause question you're saying.
And then we already have the separate cause question for the informed consent. And I think that instruction can apply to both medication and the DNI. 1022.7. That would eliminate.
Okay, so Attorney Boylan under 1023.3, that's question number 4. And I think Attorney Frankowiak, you're indicating that we should include something at the end of 1023.7, which is the causation, right?
Right. I think I'm looking right now at what we submitted for our proposed jury instructions, and it has 1023.7, and it does have a cause. It basically, or the end of your version ends with "you are not bound by any expert's opinion." I think the version we submitted has, like, we added to that sentence, and then there's a cause section that goes beyond that. So
give me 2 minutes to get that put in, and then what I'm going to do is send it to you again so you have an updated version, Attorney Boylan.
Yes, Judge, I'm a little lost on where we are here. once I find where we are, I can find it. But again, numbering is changing, so.
Off the record for a minute. Which sample verdict do you have that in, Attorney Frankowiak?
I think it was, let's see, oh, you know, the one I'm looking at, I think is the one that was filed with document 353.
Mail that to all of us, that'd be great.
Or did we?
Oh, yeah, I can take that.
I'm not sure, did I attach a version of that? The 353. Where did you get this version from?
Being sent, we're not gonna need 1,500 then, right?
Right, I think this would take care of it, and we'll send you a copy of what we were proposing. I think it mirrors the language of the 1023 point.
And so 1501 isn't gonna be needed either, the cause, normal response?
And Judge, on the issue of 1,500 being gone, which I agree with, did Your Honor place the bold on a cause versus the cause, or is that in the 1,500, which we're removing, has the words the and a, the cause versus a cause? It has those words in bold, it appears to me.
I don't think they would be bolded, but unless somebody's asking for it.
I'm sorry?
My error, but I don't think they're normally bolded, are they? It will be, unless you want to, and then we think about it, but
If we're taking out 1,500, I would request that under 1023, just one time, because it's going to be repeated multiple times, but I would request that one time the cause versus a cause is bolded, because I do think it's a significant matter of law.
Don't see, I mean,
let's just wait on substance until we get this, and then we'll go back on the record.
Is bolded in the pattern instruction.
Let us know when that email gets sent. And
Came from Mr. Navarrete? Around it, okay.
sent at high priority.
I did receive the email.
Okay,
It says it's the 1023 pattern instruction, and maybe I'm reading it wrong. It's just one word hit me, and now I'm looking at it. In the email that I got, okay, the email I got doesn't say it's modified. There's the word being at liberty, and that's not in 1023.7, the pattern instruction. And so
what I did, just so we're on the same page, is if you go down to, in that email of the cause questions,
I think we would just add the cause, everything from where yours drops off to where that picks up, we would just cut and paste or something or insert. The rest would be the cause question. In fact, I think we might need to put at the beginning, like right where yours leaves off, the next thing would be question 6 asks, the cause question, and then into the cause instruction that follows. And I think it follows pretty closely what was the similar language that was used for Dr. Shokar's.
but don't worry about anything that you just received in that email other than when it starts talking about cause.
let me get there.
Okay,
So in that email, page 2, it starts talking about the cause questions.
exactly right. And
Okay.
I've changed it to say question number asked.
Okay.
So I'll have that as the, and then, so yeah, read from there on. And
The paragraph that starts, if you conclude, this is from the email. I am confounded by it. It's 7 sentences long, and it says, if you conclude from the evidence that Grace Schara's injuries may have been caused by the negligence of nurses employed by Ascension. And then it goes on to say, well, if you conclude that, but then you may not find the negligence of nurses employed by Ascension was a cause of Grace Schara's injuries. It's internally contradictory in the different clauses that it uses. I don't agree with that.
Read, unless you are able to conclude that the negligence of the nurses employed by the hospital was a substantial factor in producing the injuries. So it's a complete thought there.
It's many different sentences and that are internally clauses internally contradictory. I would be dumbfounded by this paragraph. I am dumbfounded by this paragraph.
Bill is, I am going to save this. And do you want a hard copy or do you want a computer? You want me to email it to you?
It would help, Judge. Thank you.
Okay. I'm going to print out for the updated instructions. Each of you will get
I have
a copy. And we're going to take a break. I find in these things, so just slow down, read it, and then let's get focused. So you're going to have All right, so you'll get the updated, it's 27 pages. And then why don't we just take a break and then come back and let's try to have a thoughtful discussion. But I think we're within range of being done, right?
Yes, I think so too.
Okay.
Are we gonna get a hard copy of
You
the?
are.
Okay, thank you.
So it's being printed out. I printed it out to my computer back there by accident. So somebody will run it to you in the next minute. It's 15 minutes enough time and go to the bathroom and be ready to go. Okay, we'll see you at noon. revised pages 13 and 14 to what was sent to you. I'll have the clerk have my copy. Unfortunately, Charles Bedford was so modified it. I'll explain in just a minute. But take a look at what I just handed to you. And before I did what Attorney Guzzi, you agreed to pause questions. And I essentially copied those paragraphs, inserted the nurses instead of the Dr. Shokar, and used that form. Um, So we're going to go back on the record in 23 CV 345. Counsel, you received updated instructions from me. And then I came back into the courtroom. I handed to you hard copies of pages 13 and 14, which deal with the question number 6. And what I did after I took a look at what you proposed, Attorney Frankowiak, I thought the approach we used with question number 2 is better. A lot of time talking about it today. So I took the format that we used in paragraph number 2's causation question, substituted, the words registered nurses at St. Elizabeth Hospital in place. Changed the date until question 2. We did October 12th. That's 6:00 a.m. And I think as it relates to registered nurses, it would be during the entire hospital stay. I also that she was positive for COVID-19. We argued about that today with Dr. Shokar, but I think on October 6th she was positive for COVID-19. So if they caused anything else, including the incidents, by not informing on the 7th and 8th, similar to what we've already asked, then it would be applicable. So hopefully everybody's had a chance to kind of look through that as I explained. Start kind of where we left off. So instruction number 1023.7. I think everybody is in agreement with up to the point where we start talking about the causation. And then on the new pages that I handed to you as pages 13 and 14, what is your position on that, Attorney Frankowiak, since it involves, your clients and us not using the standard instruction that you created?
Sure. There's still an insert appropriate damage instructions in there. Do we, on page 14?
Right, and we have that with question 2, I think, as well, and maybe question 4. So that's in bold still for us to be talked about. But up until that point. There are 3 paragraphs prior to that damages and then 2 after it. So 5 paragraphs. Any objection to those as drafted?
You said that they mirror 1023.2 or what we've been doing?
They mirror exactly what we spent time talking with Attorney
Right.
Guzzi, other than, full disclosure, I changed the date because the registered nurses had contact with Grace starting on October 6th. Dr. Shokar didn't. And so we had the date of October 12th at 6 a.m. for him. When she reported to the hospital on the 6th, she was positive for COVID-19. That's why she was there. So I went back to the language that I had used. We had changed that with Dr. Shokar because there's some dispute if she was still suffering from COVID-19 or other things by the time he got involved.
Sure.
But I think the way that it's drafted with your clients is, when she presented to the hospital on October 6th, she was positive for COVID. They're not responsible for that. They shouldn't be. They didn't cause the COVID. They didn't cause any pain or suffering that she had up until that point, or anything that would be the natural progression of her COVID after that point. I think is the way that it's drafted.
Okay. Yeah, I see. I don't have a problem with that language.
Attorney Guzzi, take it you don't take a position, or? Attorney Boylan?
This was quick work for me. Mr. Barnhart can attest. That's exactly what I wanted to ask for. There's one phrase at the top of page 14 that I would request be changed. And this is where it says that Grace placed herself under the care of the registered nurses at St. Elizabeth's Hospital. I'm not so sure that's, but I would like the words entered as it was when she entered St. Elizabeth's Hospital. But again, Judge, I'm going to leave that to your sound discretion. I don't think she placed herself under the care. There's a dispute about that.
Okay, I'm okay with putting entered.
Yeah, if it said something like, as it was when she entered the care of the nurses or entered the hospital, I think entered the hospital would work.
She already was there.
Became a patient.
I just.
I'm changing that to read as it was when she entered. And again, we have those damage questions on the certain areas that we're kind of skipping over for now. So I think that takes us down then to the damage questions. I think that takes us down. And I'm still a little confused. What I'd like to make sure that we're in agreement with is 1,700 we're going to use. So we're going to circle back and talk about that. On page 17, 1722 is there. And what I understand, Attorney Boylan, is you're taking the position that 1722 can be removed.
Yes, Judge.
1722 can be removed.
Yes.
And 1722A.
Yes, Judge.
And
Can be removed.
And 1725.
Yes, Judge. Can be removed. Yes,
And
Judge.
1725. My understanding is on those
Yes,
three,
Judge.
Attorney Guzzi and Attorney Koyak, you're in agreement with that.
Yes.
Okay. You're in agreement with that. Then takes us to 1735. That then takes us to 1735. Is everybody in agreement that can be removed? And is everybody in agreement that can be removed?
Doesn't matter to me one way or the other. Doesn't matter to me one way or the other.
It was defense only. It was requested by defense only.
I mean, there's nothing wrong with it, but it's not necessary. I mean, there's nothing wrong with it, but it's not.
Attorney Guzzi, you're in agreement to take it out? Attorney Guzzi, you're in agreement to take it out? 1735 is coming out. That then would take us from 1700 to 1741. And you said, Attorney Boylan, that you wanted that to stay in.
Yes, sir.
Then the 1756
Yes.
stay in, or is that out?
That's out. According, I agree, it can be out.
Okay, in 1757?
I agree, it can be out.
Okay, in 1757? Okay, that was requested by defense only, so we're in agreement that 1756 and 1757 are removed. And does that take us then to 1766?
I believe, yes. I believe.
Stay in for now, or?
Yes,
Stay in for now, or
yes.
your position, Attorney Boylan?
That's the one I think 1855 was going to be in its place, because it's duplicative of 1855 and 1766. It's duplicative of
17, you think 1766 and 1850 are 17, you think 1766 and
1855, I believe Mr. Frankowiak is saying those are duplicative.
1855.
1855 discusses the estate's recovery for pain and suffering, and 1766 is past pain and suffering. So I think it's more proper to attribute it to the estate's recovery than 1766.
Attorney Boylan?
Yes, and then this just gets to the issue about the death that I would like.
Okay, so let's just take it out, conditioned on, the death being to your satisfaction. So I'm 1766. What about 1850?
I think that could be modified to address only the funeral expenses so that there's no confusion in the jury about sending a note over, hey, where's those medical bills? Something like that. Sending a note over, hey, where's those medical bills?
That's what we'll do for now, and then 1855 you think is in, right? That's what we'll do for now, and then 1855.
Yes, yes, Judge.
So when we talk damages, my understanding is we have 1700. My understanding is we have 1700. 1850 for the funeral.
Judge, I'm sorry, one moment if I could catch up.
For the funeral.
Judge, I'm sorry, one flip these pages. Just want to, 1700, Judge?
That's still on the table.
Yes.
1741. That's still on the table.
Yes.
1741. 1850.
Yes.
1850.
Yes. Yes.
And those are the only four we're talking about. Okay. So the question, big question I'm going to ask first is, does anybody have any problem if we do those four at the end and not do them earlier on in the instructions where it says insert damage? Or do you want us to insert these in the damage area? What's the preference? Let's start with you, Attorney Boylan.
The end is fine.
Attorney Guzzi.
The end is fine.
Attorney Frankowiak.
I would concur with Grant.
Okay, so just give me a minute and let me go through and remove those other areas where we kept it in. Those other areas where we kept it in. Yeah, let me just delete. So I'm taking it out the damage portion of 1023. Damage portion of 1023.
Part of that has to stay at least. Part of that has to stay at least.
Not sure what you mean, part of it. It's page 9. It's page 9.
Yeah, it can't all be eliminated on 23 because it makes it separate. Trucks that they can't reward, trucks that they damage the clothes, even
Okay, so let me just ask the big picture question that I asked before. My question was, is there a need to have those damage instructions throughout the instructions? Or to simply just do it at the end? Okay, so by the whole thing, we don't have anything in there yet other than the thing that says insert appropriate damage instructions. Where is it on the handout I just gave to you?
On page 9, Grace Schara sustained injuries reported treatment by Dr. Shokar. Such injuries have caused Grace Schara to endure human suffering.
I'm with you there. So I'm with those paragraphs in. So if we keep those paragraphs in, you see the part where I left in bold, insert appropriate damage instructions? Do we need to insert anything further into 1023? Okay. Okay. Okay, good. So I thought that was sort of the answer.
And I think the same would apply to 1023.7 since they're basically mirroring each other.
And that's on page 14, so I'm gonna take out that bold.
Right.
Okay. Okay, so that takes us down then to instruction 1700. Tell me, Mr. Boylan, what you're picturing with respect, the instruction 1700, 1741, 1850, and 1855, which I think are the 4 that we have left.
Okay, Judge, so on 1700, the first paragraph about answering the questions, I do think it would be appropriate for the court to answer the funeral expense instruction.
So just give me a second.
And that's it. It's a pattern instruction, and the appropriate names can be placed where they're placed, and the appropriate numbers for the questions can be placed, but it's, I believe I'm satisfied with the pattern instruction with the court answering the funeral question. Funeral expense question. And You mentioned a number of instructions, Judge, so I can move on to any others when you when you would like me to.
Okay, just give me 1 second.
Okay, that's where I want to be sure I'm not ahead of you.
Just give me 1 second.
Okay, that's where I want to be sure I'm not ahead of you.
On what? 1700?
Yeah.
I do. Let me do, if you don't mind, let me just try to catch up. I do. Let me do, if you don't mind, let me just try to catch up. Okay. Attorney Guzzi, are you going to comment on whether or not there's a stipulation? Are you going to comment on whether or not there's?
Yeah, I don't have a problem with the insertion of the funeral bills, Mike. Yeah, I don't have a problem with the insertion of the funeral bills, Mike. And I also paragraph.
Okay, so let's just deal with the stipulation. What was the amount? I know it was 11,000. What was the amount? I know it was 11,000.
I'll pull that up real quick, Judge. I hope. I'll pull that up real quick, Judge. I hope.
I guess in terms of answering or putting funeral bills in there, I objected to the funeral bills to begin with, as I don't think they were properly admitted. But in terms of the court's decisions to put them on there, I don't have an objection.
Are you objecting to the stipulation of it, given the fact that I let it in? Are you objecting to the stipulation of it, given the?
No, in terms of answering this, I don't object to that. I just object to the fact they're on there to begin with.
Judge, we'll get to the exact number on the funeral bills. I think I had it on a thumb drive, which I gave to the clerk for the exhibits. So I don't see it right now, but we'll get the court that promptly. We'll get the court that promptly. Oh, I could get it maybe here. 1 second. Oh, I could get it maybe here.
Defense know that dollar amount, or can we get the exhibit?
I can. That's where I'm going to look. I can get the exhibit. Yes. I can. That's where I'm going to look. I can get the exhibit. Yeah, don't. Yes. I'll get it in 1 second. Yeah, don't. I'll get it in 1 second. It's exhibit 106, Judge. It's exhibit 106, Judge. The number is 14,000. The number is $137.89. Exhibit $1.89. Exhibit 106.
$14,237.89.
Yes, Judge.
$237.89.
Yes, Judge.
I have put that on. I have put that on. Okay, and then I think we're up to the second paragraph. Attorney Guzzi, you said that you don't want the second paragraph in there. You said that you don't want the second paragraph in there.
They don't answer the end question. They don't answer negligence. Or what cause answer negligence. Or what cause.
Attorney Boylan.
I don't think it's error to include the question, to include that instruction. I don't think it's error to include the question, to include that instruction. I'd just want to look on the that we've all agreed to, whether it tells them don't answer this question. Well, then it's consistent with the verdict to exclude it, Judge, because your verdict says answer those questions only if they answer the others. So I would agree.
Okay, so that second paragraph is being removed, then the third paragraph. That second paragraph is being removed, then the third paragraph. You know, in the damage questions, they should disregard any percentages. Answer the damage questions, they should disregard. Done in question 7, I think that stays in. Done in question 7, I think that stays in.
Still a comparison question. Still a comparison question.
Okay. The following paragraph. So any other questions with 1700? So any other questions with 1700?
I agree. I agree.
So that, I think you called it the 5th paragraph. It's just going to say your answers to the damage question should not be affected by sympathy or reason. Your answers to the period question should not be affected by sympathy or resentment. Period. The rest of it. Nor should you make any deductions on one. Nor should you make any deductions on one.
I just want to follow where we are. I'm sorry. Randy, could you repeat? I'm sorry. Randy, could you repeat? We're taking that out, correct? We're taking that out? Yes. I agree. Yes. I agree.
Just give me a second. Just give me a second. The note that says do not use this paragraph if 202, that's out, right?
As well as the whole paragraph, yes. As well as the whole paragraph, yes.
And then the paragraph regarding pain and suffering. And then the paragraph regarding pain and suffering stays in. Stays in. And you want me to add in personal injuries for lack of informed consent? Add in personal injuries for lack of.
I would request that. I would request that.
And I would join.
There was not a separate line. That was
Give me a second. I'm trying to focus in on what you're bothered about. So if the jury has to fill in B and C, I mean that's the beginning part. If I allow that to go, and you're afraid that they're going to duplicate, they're going to count twice. But and we tell them not to count twice, right?
bigger concern, the big concern is it's not a category of damage. It means something here, or if the system was involved in the death of future pain suffering. Personal injury damage is just category of damage.
1741 says it is. It says they inserted in their answer.
Okay, so let's circle back, but for now, when we get to 1741, we can discuss it further.
Well, let me just ask you this, John. Maybe we'll keep that on, if you don't mind that.
Yeah.
You're not suggesting that there's been two separate caps.
No, on this issue, no, there's still a cap of 650. Subject to that's gonna be an issue for appeal if the cap's constitutional, but no, the cap is the cap.
A little less, I think, still, again, there's no instruction that defines that cap.
I think there is, but we'll get to that when the judge asks us to.
Okay, so as of right now, we're done with 100.
We're keeping the very next paragraph as well, the very last paragraph, I believe.
Yes.
Okay.
Okay, so now let's go to 1741.
And is it my turn, Judge? On this, I think, there's the parenthetical about it, their doctor or chiropractor, dentist, so on. I just think that should say defendant. And then we need to conform patient as well to either Grace or her POA. Each of those parentheticals, there's 4 of them total throughout the paragraph. Actually, I think there's 5. Patient and.
Okay, so let me just understand something.
Mhm.
Is it your position that 1741 deals with the answer to 8B?
It is, yes.
Okay, so shouldn't we specify that at the beginning of 1741?
I don't object to that.
Okay. Attorney Guzzi or Attorney Frankowiak, what I'd like is if we're going to keep them in, and right now they're both B and C, so I think it's appropriate to then say in answering AB, 8B, do the following so that we know they're not going outside of 1741. Any problems with that?
If it's going to be there, yeah.
Okay.
And I would just say, because somebody else didn't include it, I'm not liable for what they did or did not do. The damages are defined in 1700. No mathematical precision. You must award the damages that you find. And it says insert them in the answer. So that I'll rest on that, Judge.
Okay. So let's just try to work through it. And so looking at 1741, if you have determined, and we agree this has nothing to do with the nurses, right?
That's right.
Okay.
There's no
Right.
informed consent duty, so
Okay.
we shouldn't deal with that.
So if you have determined that Dr. Shokar was negligent in informing, and I think to stay consistent, we'd add in Grace Schara and or her power of attorney.
Yes. I think it could. I don't like and or just because it confuses me. Or I would prefer just or. But I'll leave that to your.
Yeah, if they had been in the room, they may told Grace about the informed consent, I think you'd still have a problem with it. You'd want the power of attorney to be informed. So I'm gonna keep it and/or.
Okay.
You will insert as to your answer to
Eight
question
B.
8B. And if I take out patient and I put in compensate the plaintiffs,
Yes, Judge, I would agree.
for the injuries suffered by Grace,
I agree.
as a result of Dr. Shokar's negligence. Okay. We're not adding in a personal injury damage instruction, correct?
We don't need to, but I think that answers Mr. Guzzi's question because the pattern instruction, that language comes from the pattern instruction. It says add the damage instruction, which is 1700. That's what it is.
I'm sorry, go ahead, Mr. Guzzi.
That's solely attributable to whereas all within the pain and suffering, all one category of damage.
I lost you on that concern. By the apportionment question, you're talking the comparative negligence?
Yeah, how do you apply if they come back, for example, and say Shokar 30%, nurse 70%.
Right.
What number are we applying that to?
You're talking specifically to 8B?
Yep.
I think if they fill in the line and say $10 million on 8B, we would know it's zero. Or not. Because I thought Dr. Shokar would need to be more than 30%.
Well, he'd be contributory in that.
Yeah, but there's no contribution with respect to informed consent.
But you're not, of course, you're not constructing the apportionment question on informed consent. It's an overall negligence question.
So the apportionment question should relate to only questions 2 and 6. If the answer 2 and 6, yes.
Because I think we are creating a problem with the, we look at the single verdict, address that whole concept. We have separate negligence, separate questions on informed consent, all got rolled into pain and suffering. So I think we're creating a potential issue that we don't have to. No reason to do it.
So are you suggesting, let's go back to the last point before we argue Mayo again. So I thought we were talking about comparative negligence and your concern about, the combination of informed consent and negligence into the comparative negligence question. And
yeah, I'm just raising the question, does it cause a problem with comparative?
I don't think that should have anything to do with this question, right? If it creates an issue, then we should address it before we start talking about damages. So should we only do questions 2 and 6 on the comparative negligence?
I think that has to be, those are the only two parties. Now that we've taken Mr. Schara off the verdict, there's only two parties to compare. So you're only going to compare if there's yes to the cause question, or wait, there's multiple.
And go back to your question on Mayo, which I saw the email. I haven't looked at it because it just came in. But maybe the response to that then is they answer 8B only if they answered question 3 and 4, yes and yes.
I would further, however, the court because my position is not going to change. I don't think there's one. I don't think there's a basis to separate.
No, but instead of re-arguing, so let's stay, so do you think it'd be good to, or better to avoid confusion if we said answer 8B only if you answered 3 and 4 yes and yes?
Might have to be the way it is.
I'll leave that to Mr. Goosey. I mean, if you,
So that's an issue, and we'll resolve it after lunch, but I now want to understand what you're trying to say. Mr. Guzzi, because I interrupted you.
But this, again, in those situations when there's no basis, no law, no jury instruction, there is no, every other category again has a specific instruction that describes the type of damages that can deal with. Pain and suffering. Describes how the jury reaches their determination for pain and suffering. Medical bills, funeral bills. I also think that this goes back to what I mentioned with 895, which is 890, especially we're talking about before, in terms of everything being one concurrent act. I don't see why we're doing it. I don't see the basis for doing that. Properly instructed jury.
1741 could not exist if there were not monetary damages for personal injury resulting from negligence in informing the patient. That's entirely what is it about. It's not a cause question.
I got an email from you, but I don't think you attached anything to it. I'm going to wait for you to send that. Then I have a question for you, Mr. Guzzi, but let's try to do one thing at a time. Okay, I'm still waiting for it. My question for you, Mr. Guzzi, is in light of what you have brought up, it sounds to me that you're suggesting that if we don't go along with what you're proposing, and again, I haven't looked at it, that because 8B is directly connected with the informed consent, and because the nurses have nothing to do with the informed consent, that 8B should connect directly with questions 3 and 4. And then I think what you also said was because the comparative negligence, it might have been you, Mr. Pincoliak, because the comparative negligence now only involves 2 parties, the nurses and the doctor, that we should connect those 2, meaning we connect 1 and 2 with 5 and 6 when we ask question 7. And question 7 should have nothing to do with 3 and 4. And then when we get down to the damage question on 8C, that would connect directly to their answers to 1 and 2, 3 and 6, and then 7. And we would let them know that. So answer 8B only if you've answered yes to 3 and 4. Answer 8C only if you've answered yes to either 2 or 6, and regardless of how you answered 7.
I said that I misspoke. No, I think it's all got all one thing. Because otherwise we're getting into, do we then designate nurses, negligence, separate that out? I think it's all kind of stuff earlier today is one occurrence, all negligence wrapped it to that one occurrence, and that goes very much. Don't think that separated. I say damage, but I don't think separated. What other damages are there?
Now we're arguing again instead of doing the format. I had not thought of that, to be honest, and we've been bothered and we've talked about it. And as recent as last night at 11 o'clock is after I made that change for you guys, when I went from having 6 categories to breaking it out into 1 and 3 and each having 3 categories. But I think you're right that informed consent doesn't have anything to do with the nurses.
The nursing care doesn't have anything to do with that. That you start
Okay.
going on that
So you're comfortable and basically waiving any opportunity for appeal if the informed consent answers combined with the standard of care violations in the care and treatment by the doctor and the standard of care violations in the care and treatment by the nurses, that we combine all of that together in the comparative question.
I think that's a better,
Okay. But if you're good with that, then I don't think you're going to be able to come back and say, then it was an improper verdict and my client, is he some portion of the nurses. If that's the way you want it, then that's the way we'll do it.
No, that's the way it's got my argument is that it's not typically a separate category yet. That's what gets us into the issue of comparative. I think I've made my record. I don't think it's appropriate to have a separate category. I understand what 741 does.
I'm not sure how anyone's gonna be able to determine what is a personal injury for lack of informed consent, because we don't have a jury instruction to tie that to. I don't know how we tell people what that is. How do you determine that? Because it's not tied to anything. I've never seen that before, and it certainly has nothing to do with nurses.
Before?
What's that?
You never have seen what before?
I've never seen a category of damages for personal injuries for lack of informed consent, because lack of informed consent, if they find a lack of informed consent, that then gets them to the damages. It doesn't create an extra category of damages. It just gives them another reason in case there's no negligence, they don't get to the damages. But if there is a failure of informed consent, they get to access the damages. All the finding on a failure to informed consent gets you is access to the damages. It doesn't create an extra set of damages. So it's just a second kick for the plaintiff to get to that category of damages. But the category of damages is the same. It's the past pain and suffering. There's no separate category. It just gives the plaintiffs multiple avenues to get to those damages. And I think that might be what Attorney Guzzi is saying. So we just have funeral and burial and past pain and suffering. Now, how do the plaintiffs access those category of known damages? It's if they can prove that Dr. Shokar was negligent, or if they can prove, even if he was negligent, if they can prove he failed to obtain informed consent, now they can access those damages, funeral bills, pain and suffering. It doesn't create a separate section because our personal injuries for lack of informed consent, are those non-economic damages? Are those economic damages? Are those pecuniary damages? I don't even know what to call them because they're not defined anywhere. Past pain and suffering, I know that's a non-economic damage because pain and suffering, loss of society, those are non-economic damages. That has implications for the cap and things like that as well. I don't even know what to do with the personal injuries for lack of informed consent. Clearly the nurses can't be, that couldn't be awarded for, if they say they find the nurses negligent, causally negligent, they can't answer that. I mean, if the nurses are the only ones found causally negligent, they can't answer or award something for B because it has nothing to do with it. It doesn't exist as a category of damages in and of itself. So I would join Attorney Guzzi in saying category B just doesn't have any existence in the law. I don't know how we're going to tell them, how do they determine what that means? What does it mean to have a personal injury for lack of informed consent? How do I monetize that? We can explain through the jury instructions how to monetize past pain and suffering because there's an instruction for it. We can't tell them how to monetize personal injuries for lack of informed consent because there is no such separate category of damages.
Your Honor, if I may, I want to be clear. This isn't a concern about, it's not necessarily a concern about them getting another kick at the can on damage. I just think creating a potential issue that doesn't have to be there. I mean, I agree with Attorney Francoya. The determination that there's negligence cause in the informed consent gets them to damage question on past pain and suffering. There's just no need for a separate category that's completely undefined by any instruction.
All right, so I'm looking introduction to question number 8 on the verdict form, if you want to get there with me. And I think based upon what has been indicated, there's an agreement on the funeral amount. So I'm going to fill in 14,000, 237.89. Correct?
I agree.
I know I did it on the instructions, but on the verdict form, that's going to be filled in. You agree, Attorney Guzzi? And Attorney Francowiak?
To enter the funeral and burial?
Yes.
Yeah, I guess subject to my objection to having them on the verdict in the first place, I don't have a problem with that stipulation.
And so all we need them to answer is 8B and 8C. So instead of introducing question number 8 by saying answer the following question only if you have answered yes to question number 2, question number 4, and or question number 6, the introduction should be answer question 8B if you answered yes to question 4, period. Answer question 8C if you answered yes to either question 2 or 6. And at least when you're the jury, you're going to connect. You're only going to answer 8B if they in fact find an informed consent violation and cause an injury or death. And they're only going to answer 8C if they find negligence and a cause of injury or death by either or both the doctor and the nurses. And so, first of all, that's fundamentally correct. Second is it avoids duplication. We've told them it's not going to be duplicated, but they should not then answer twice for something or build in. They should go to, for example, if they're sitting in the jury room and they answered 4 yes, the introduction is going to be clear that they answer only 8B. And then they're going to go to the instruction that we just talked about, and they're going to read that instruction and then fill in the line.
And that instruction has to do with informed consent. And the question I had for you before, Mr. Guzzi, I'll modify this and you'll have a draft of it shortly, but why would they have that instruction, informed consent instruction, and, you know, as it relates to damages? When would it ever apply?
Always, it would always apply. Because I believe the informed consent statute has it.
No, I'm talking the jury instruction.
So much.
Okay, so I thought you said it doesn't apply.
No, that's 1741. I'm not saying it doesn't apply. I'm saying all it does is tell them that they can award damages for it. It doesn't give them any indication of what the measure of damage is, how you determine it. And I think back to
Let me just stop you for a second. It says, insert as your answer to that question the amount of money which, under the evidence, will reasonably and fairly compensate the plaintiffs for the injuries suffered by the patient as a result of that negligence. How does that not tell them what to consider? They're told, fill in the amount of money that you think is appropriate to reasonably and fairly compensate for the injuries as a result of that specific negligence. And maybe they think it's $10, and maybe they think it's $1,000.
all one occurrence, one set of damages. Otherwise, where do we stop? Do we break up nurses' damages?
It's because you're saying it can't be apportioned.
I mean, if you want me to, we can.
I don't think any of it is appropriate based on the
It's probably more favorable to Dr. Shokar if it's apportioned and he gets a discount, if there's ever a number inserted.
What is a personal injury for lack of informed consent? I guess I'm having a hard time conceptualizing that. Is that a non-economic damage? Is that a pain and suffering? Is it a loss of society? Is it a pecuniary injury? It's not defined anywhere. So what do we call it? That's important because of the cap issue. We know that past pain and suffering is covered by the cap because it's covered by non-economic damage. What is a personal injury for lack of informed consent? It's not defined as anything. It's not defined as pecuniary. It's not defined as non-economic or economic. It just is an undefined category of damages.
We stipulate it's covered by the cap.
I've never seen that. This will be the only case I've ever seen that has a undefined personal injuries for lack of informed consent. I've never seen that before. I'll probably never see it again. I'm not sure what to call it.
Okay, so now that we're seeing it, because this case has shown it to us, I think we got to figure out how to deal with it instead of just saying, well, we've never dealt with it, and you know.
Attorney Francois point is that this has been dealt with in every single one of these types of cases.
Where's the case law that says that?
I can't give you a specific case, but
To me during lunch, if you don't mind, because I don't think there is. But I do appreciate what you brought up, and I feel bad that we're going back to change our verdict form, but I think it's probably better to do it, which is why we have a day doing it. So I'm going to change it the way I just introduced it, that question 8B and 8C need to be answered. Only answer 8B if you answered yes to question 4. Only answer 8C if you answered yes to either 2 or 6. So that'll be updated. I think this is probably a good spot to take a break. You guys will get from me in the next 20 minutes my updated instruction and my updated verdict form. How much time do you need for lunch? An hour? Or okay. And I've taken a look at what I'm going to accept the stipulation that is covered by the caps, is what you're saying?
Yes, Judge, subject to the fact that we could appeal that issue as a constitutional matter, and it's not for the circuit court to have to address.
Any objection to that stipulation?
Run that by me again.
We agree that it's subject to the caps, but on appeal, post verdict, we may raise the constitutionality of the caps. The court's already ruled on that.
Attorney Guzzi? Attorney Franco yet?
To the objection to the damages themselves, the stipulation certainly would be accepted.
Okay, and that sort of, assuming that what we're doing is constitutional, and I think we all agree it's constitutional now, it may get changed.
I don't agree it's constitutional, but the circuit court is not in the position to do that. Only the Supreme Court could.
Right, so if they change it someday, this will still be in the cap, what you're saying.
Yes, unless the cap's unconstitutional.
Okay, so I'll get those to you in the next 20 minutes. We'll take a 30-minute lunch. We'll start back at 20 minutes to adjourn. needs to be the same jurors as the cause?
I believe the same 10 jurors must agree for each of the elements for each claim. So if there's a negligence claim against each party, the same 10 jurors would need to be the same for negligence, for cause, and for damages.
Okay, and I incorporated that into the changes or the additions that I built out in the introductory paragraph to question 8, where it says there needs to be at least 10 of the same jurors. So if you see that. Excellent. Attorney Boylan, any questions or issues with the special verdict form?
No, Judge, we agree.
Well, I think what you have in front of you then should be the final copy, unless we change it between now and the time that we finish.
I'd agree to go home right now.
Yeah, I think we're getting close. So then if you turn your attention to the 17 pages of jury instructions, during the break, I think our attention kind of where we left off, and what I did was starting with 1741. That instruction at the bottom of page 15 is, and I understand defense doesn't want it at all, but in the event that it's given, that was what we discussed before the break. I don't think I made any changes to it. I did make changes to 1855 on the top of page 16. Does anybody need a copy of that, or?
I have it on my computer screen. I don't have a printout, but I've got my computer screen.
Okay. Do you want me to print out a page for each of you?
I'm okay right now, Judge. Thank you.
Okay. Okay, so I did touch that up. I took out the funeral expense instruction. I don't have the number in front of me, but I don't think that's needed anymore. So after we read 1741, we would then read 1855. I think the one thing we could do is have the introduction that applies to question 8C. I think the second thing that should probably be discussed is, I know you wanted to be able to argue death.
I'm fine with it.
Okay, yeah, I was gonna say, I think it's in there where it talks about deceased.
I'm fine with it.
All right, so you're fine as drafted?
I'm fine with the jury instructions as they now are drafted in the email that you sent moments ago, Judge.
Attorney Guzzi, maybe start with 1855 first. And so are both of you in agreement then I don't have to introduce question 8C? You're okay without it? Attorney Boylan? Yes?
Yes.
Okay. And then Attorney Frank Koyak, anything on 1855?
No.
Okay, so then what you have in front of you are 17 pages of jury instructions. Other than the arguments that you've made, are there any changes, additions, deletions, or issues that you'd like to discuss? Start with you, Attorney Boylan.
None, Judge.
Attorney Guzzi? Okay, so we got captain of the ship to discuss.
The wording is fine. I think it should be folded into the discussion where it's about how somewhere else in the verdict, I'm sorry, Judge, somewhere else in the instructions, there's a discussion of how Dr. Shokar is not liable for other people's actions. And so I think that paragraph that Attorney Guzzi proposed, the language he proposed, can be used, and it can be put in that area, because we won't be using a title or a number for the captain of the ship topic generally.
Okay, so let me. Attorney Guzzi, I have one paragraph. Correct? And I'm going to remove the title. So the question is, where would you like it inserted on the instructions?
I'm thinking that maybe right after 1023.7.
So right before 1700?
Yeah, I think that makes the most sense to me, but to me it flows, it makes sense to have it after you've instructed them about the negligence of the negligence. Okay.
You like that more than up when we were talking about Dr. Shokar?
I do.
Then why?
Well, I think it just reiterates after the jury has been instructed on the standard of care for the nurses, just to reiterate to them that he's only responsible for his own actions. I mean, I'm not locked in on that. If there's a reason, put it somewhere else.
Okay. And we would just put it at that bottom without a separate number, or would you want a separate number?
I think maybe we should put a separate number, maybe make it a 1023.7A or something. I don't know. Whatever it says.
I'll do 1023.75, which is what we did with the other one.
Yep.
We just add a 5 behind it. I'm going to change the MD part, just call them, consistent with the rest of what I did, to use suggesting that Dr. Gavin Shokar. Is that okay with you?
That's fine.
Okay, so I've inserted that in.
And Judge, for the clarity of the record, this is the document that was attached to Attorney Goosey's email this morning at 10:16 a.m.
Yes.
Thank you.
It's one paragraph.
Yes.
Anything else, Mr. Guzzi, as it relates to the instructions then?
I don't think so, Judge. We got it.
Goliath, we were on any objections, issues, concerns?
No, Your Honor, beyond those already stated on the record, nothing further.
Okay. I have just modified the instruction. What I'll do is spend some time in the back and just double check spelling and font and stuff. And I will forward to each of you then a final jury instruction and verdict form. I'm not going to make any substantive changes. If I did, I would probably do an email that I'd want to talk to you at first. So this will be what it is. But if I notice a typo, which it shouldn't be because I spell checked it, but just spacing so the pages look right, things like that. And you'll get that shortly.
Judge, spell check's not infallible. I mean,
No.
my brief, that overdose came out as overdose.
Judge, do you want us to wait here for that? You said shortly, or
No,
you mean
no, you can
this
go.
afternoon?
I'll email it to you. Yeah, I plan on doing it before I leave. And then, my thought on it is, and Attorney Guzzi, you haven't followed up on your preference with respect to the verdict form. But the further we've gotten into this morning, my plan is to make copies of the instructions and the verdict form and let each of them have it as I'm going through it so they can read along, they can look at the verdict form. When I'm done giving my instructions, I will tell them to set that down so that's not interfering with your closings. And only to pick them up if you guys say, hey, if you pick up your verdict form and look at question 2 or something, then they can pick it up. But that way I'm not gonna have to reprimand them in the middle. So when I want them to have them when I'm going through them, and I don't wanna impact your guys' closing. So I'll say, here they are, they'll be handed out. Now, when I'm done, I'm gonna say, set them down, and the attorneys will let you know if you need to reference them. I don't have any problem with them taking it into the jury room either. So when they're sitting around a table, they each have their copy, and they don't have to stand up and look over somebody's shoulder. That's a separate issue. So 2 prongs. Attorney Boylan, any issues with them having the instructions and the verdict form during the time that I'm given the instructions and/or your closing?
No, Judge.
Attorney Guzzi?
As long as they have a magic marker and they fill it in, I instruct you on fine.
Won't have writing utensils. But you want them to?
No.
Okay.
So I mean, there's been a lot of use of stuff. I've never seen the jury questions before. I'm not 100% sold on it. So I'm really impressed with it.
Yeah. Attorney Frankowiak on that first step?
No problems, Your Honor.
On the issue with them taking their copies with them into the jury room, any issues?
None, Judge.
No, Judge.
No, Your Honor.
So you didn't like the questions, Attorney Guzzi? So the last trial that I tried before I became a judge in 2005 was after I was elected. And I went up north and tried a couple $1 million case, kind of like what you guys are doing.
Are we still on the record?
We are. We can be done if you want, but I on this case, I want everything on the record. And the judge did it, Judge Hatley, who retired shortly after that. And I was opposed and I was a lawyer. And then as the trial went on, I thought, wow, these are great questions, whether they were good or bad for me. Just like they're paying attention. It got them to pay attention more. They were asking questions. It helped me in some situations because I kind of could get a read on what they were worried about or thinking. And in others, I got nervous because you go, oh, they see our weakness. It was during that experience that I thought, wow, I'd never experienced it. No matter how the verdict comes back, this is what I'm going to do when I start. Yeah. That's right. But it also gives you the chance to. Because if one of them is asking it, there's more than.
I think they still teach that at judicial college as an option.
I was a dean, and I think they just teach as an option. And
As an option,
kind
yeah.
of, but I think it's minority. But in any event, appreciate the feedback. Don't base it on what the verdict is, right? It's just a matter of you got to assess it right now and say.
Yeah, I mean.
Okay. All right, I'll get those shortly to everybody. Tomorrow, we'll start at 8, I would expect, right? So we're not going to have any issues. We'll do like a break at 9:30. So if you're in your closing, Attorney Boylan, again, I don't want to stop you, whoever it is on your side, that I probably won't stop in a difficult time, but I also don't want to rush you, but we have somebody who needs to nurse. So I think it's likely we'll just take a break at 9:30 and I'll stop you at that point. Then when they come back, we'll do another 90 minutes and just kind of stop wherever you guys are at. If that's okay, and if I say, hey, is this a good time to take a break? If you were to say, I only have a couple more minutes, I would give you that. So it'll be up to you on how you want to do it. But I don't want them itching in their chair and you have 15 minutes left and they're not listening to you. I'd rather take a break and bring them back and have them listen to you. Okay. Who's doing the closing? Do you know?
The captain of the ship, which is Mr. Administrator.
Okay. And then are you going first, Mr. Frankoliak?
I would imagine.
Okay. Signal to me something different if that's different. Otherwise, I'll go to you first and then to you. And you're going to let us know, is Miss McInnes going to be with you or not?
Yeah, I can certainly let you know.
Okay.
If she'll definitely be here, but whether or not she's sitting here or back in the gallery is up in the air. Is that something you'd like to know before tomorrow?
Well, I just think, I mean, that can be twisted a couple different ways, and I think it's your choice, so you do what you got to do.
Okay.
I think it makes sense to have her there, but if you strategically, I mean, I think it could bite you if you don't. I think you're going to use it to your advantage if she isn't. You know, I mean, you're not going to stand up and say she's no longer sitting here because Judge McGinnis dismissed the battery charge.
No,
Okay.
no, it's not going to be. I'm not going to mention her presence or absence at all, but I would imagine she'll probably be here.
Okay.
Sit next to me.
That wouldn't be proper, I don't think.
No, this is, I just haven't thought about it now.
It was.
How far can one of us go to address it? The door is so far to say that it's dismissed by the.
I start my analysis by, I had cautioned or warned plaintiff of that possibility and be careful in bringing it up because by the end it might not be there. So I think you guys were on notice. It was brought up, and there was testimony about it both ways. So I don't think there's any problem if somebody were to mention, you know, the court dismissed the battery cause of action, so that's not on the verdict form. And I would think you'd start with it. And if the plaintiff were to address it in their opening, I don't think there's any reason for you to do it.
I'm sorry, Judge, you said what?
I think it's fair for someone to bring out to the jurors' attention that they've heard a lot about battery, but battery is not on the verdict form. You get to go first. So if you want to caution the blow and say that, you know, that the court dismissed the battery cause of action, so it's not on the verdict.
Understood.
If Mr. Administrator doesn't want to say it for whatever reason or forgets to say it, then one of them can say battery's not on there because the court dismissed it.
Understood. Thank you.
Okay. No, that's okay. And I think that's, you guys good with that ruling? Yeah. Okay. Thanks, everybody. You'll get that within the next hour, okay? We're adjourned.
We're on.